Good evening and welcome to the regular meeting of the San Francisco Ethics Commission for February 23rd, 2015. Calling the roll, Commissioner Han. Here. Commissioner Keene.
Here.
Commissioner Andrews.
Here.
And Chair Commissioner Herr has been excused. Item 2 on the agenda, public comment on matters appearing or not appearing on the agenda that are within the jurisdiction of the Ethics Commission. Does anyone have any public comments before we move to the next item? Hearing none, I'll turn to the third item, which is a presentation by San Francisco State University students Kristen Wolslegel and Jeffrey Thorsby regarding their campaign finance data visualization project regarding the November 4, 2014 election. And welcome, and look forward to your presentation. And thank you. You can come up. Yeah.
Stephen Massey, I'm the Information Technology Officer. I just wanted to take a moment to welcome both Kristen and Jeffrey. And they've been interning with us from the Masters in Public Administration program at San Francisco State, and they've been learning about the laws that we administer, the data that we collect, and data visualization software that we use in the office. And in the past 2 months, they've been able to produce a data visualization report on the November 2014 election. And I don't want to take away from their presentation, but the work that they've been able to do in the past 2 months is very impressive, and we've been very lucky to have them. So,
thank you.
Thank you. Can you hear me? Yes. My name is Kristen Wolslegel. Thank you for giving us the opportunity to speak with you this evening about our project. What we'll be showing you tonight is a data visualization and data analysis project that analyzes campaign finance data from the full 2014 election cycle. So previously you've had the opportunity to look at campaign finance data on the Ethics Commission website in real time. So leading up to an election, you could look and see who the largest contributors are and get a sense of the landscape of campaign finance. But what we wanted to do this year was once the end-of-year filings come in at the beginning of 2015, to get that full aggregate year data and do an analysis of entire spending on the election cycle. So what we'll be showing you tonight is a preview of what will eventually be going live on the Ethics Commission website in a few weeks. And we mined through data from San Francisco's Open Data Portal, publicly available campaign finance data. And I'm going to pass it on to Jeffrey, and he'll tell you a little bit more about the specifics of the project.
Hello, thank you again for having us. My name is Jeff Thorsby, and so as Kristen mentioned, we took the data from the Open Data, San Francisco Open Data, and we've actually used a data visualization software called Tableau. It's interactive and allows us to create almost essentially a story with chapters and sections to tell a story of what happened in 2014 and financially in the campaign finance data. And so when we started really looking at it, Jesse and Stephen really highlighted 6 really specific kind of sections that can kind of encapsulate that story that we're going to try to tell. And those sections include, first one, total spending was totally spent in 2014. And also, I should note, this is all within the county and city of San Francisco, in addition to the assembly race. It was also specifically within the county jurisdiction, probably not jurisdiction, but within the lines. Additionally, second section, we're also looking at the different types of contributors and the recipients of those, and who are the largest contributors and the recipients of those expenditures. We're also looking at lobbyist and campaign consultant data, as well as county central committee data, political parties, and then PACs and general committee data. So with all of those, generally we get a really good sense of what happened in 2014 in the election cycle. And again, so essentially our idea is eventually we're going to be posting online interactive story that has chapters and sections of that story. And so I'll go ahead and pass over to Kristen. She can kind of launch us into this preview this evening.
Thank you. So Jeff and I will be going back and forth for the following 6 chapters of this analysis. So the first one is total campaign spending. And give me a moment while I just get this centered here. So we found that nearly $25 million was spent by candidate and ballot measure committees in the November 2014 elections. This particular analysis here does not include the June primary elections, just November. And the circles here are proportional to dollars spent. So the large green circle is nearly $22 million that was spent by committees on positions positions that have won. And instead of saying winning elections, we'll say the position won, because many of these expenditures were to oppose ballot measures or candidates. So expenditures for winning positions was about $22 million, and expenditures on losing positions was about $3 million. This amount includes independent expenditures and direct spending together, and it is all San Francisco elections as well as the statewide state assembly elections. So with this visualization, you can interact somewhat with the data. So we can drill down a little bit further and look at how much was spent specifically by candidate committees. And we found that over $7 million was spent by candidate committees to either support or oppose them. And the green circles are representing, again, size proportional to expenditure, representing either supporting or opposing candidates for positions that won. And what you can do is click on these circles, and you get a pop-up table below that shows you specific details about the expenditure. So in this case, we see that these were expenditures to oppose candidates, but they ultimately lost. These were 2 committees that were formed to oppose David Chu, and you can see what they spent here. Another committee formed to oppose Jane Kim and what they spent here. So this just gives you an example of how you can manipulate the findings here. And then looking on to money spent on ballot measure committees, the same visual layout here. What's interesting about the ballot measure committees is that most of the money was spent, I guess successfully, you could say, was spent on elections that had the intended outcome. And 3 times more money was spent on ballot measures than on candidate committees, which is also interesting. So you can also click on these and look a little more closely at the details about how the money was spent. So you could look at specific measures, the committees formed to either support or oppose them, and then the expenditures made. So that's just a snapshot of total spending. I'm going to pass it on to Jeff now.
Right. Thank you. So with this section, this page is kind of looking at is the total contributions per contributor type. Let me scroll down so we can get a good look at. Oops. Sorry about that.
We're actually connected to the internet right now, so there may be some lag time.
Okay, yeah, sorry about that. Those are some extra little previews for you. So what this shows is actually, we can kind of see at the very top there, we have a bar that essentially shows the total spending in 2014, and the different colors represent the different types of a contributor. You'll notice green is other, which generally includes corporations, LLCs, corporate type entities. The yellow or the orange indicates individuals, blue is committees, and then red, which you cannot see because it's so small, those would be our small contributor committees. But what's interesting is, so one can basically look at this chart and they can start clicking, and they can see you'll see that the bubbles will change, so they can really start seeing each bubble represents an actual contributor, and you can actually scan over and start getting some information about that. And to go back from the very initial section, which which kind of contributes to why data visualization can be an effective tool to communicate information, is that we can see some pretty big outliers. For example, for other, we can see FC Pier 70 LLC, American Beverage Association. Those has contributed a large amount, $9 million for that one specifically. We can also see different individuals. And so what's kind of exciting about this is then people can really dive into the data, and right here on the right, it's actually a bar chart on the right. That's the individuals. But the bar chart on the right can show the recipients, which is hard to see obviously right now. But generally speaking, definitely the top 5, if not more, the top recipients were ballot measures. So we really do see a pretty clear trend on what's being spent by contributors. With that, we're going to move forward.
So we also looked at expenditures on consultants. And what we found that over $12 million of that initial $25 million that I mentioned was spent on consultants, either to support or oppose a specific ballot measure or candidate. So looking at the first visual here, this large circle represents expenditures on ballot measures, and 88% of all the expenditures for consultants was either to support or oppose ballot measures, with 12% here being to support candidates. In fact, all of the consultant activity was in support of candidates, whereas consultant activity for ballot measures was either to support or oppose. We'll see in a further visualization that the bulk of those expenditures for ballot measures was on Measure E. And Measure E activity really did dwarf all of the spending in the rest of the election cycle. So if you click on these bubbles, you can then look at the bar graph here. And what I did was I aligned whether the election outcome, similar to what I showed in the total spending, did consultant expenditures have the desired effect? Did it help to spend money on consultants? So certainly for ballot measures, we see that by and large, that large bar there is expenditures on positions who's won. Again, this was primarily Measure E. If you do look more closely at the rest of the story, which I'm not going to show tonight, you'll see those exact expenditures on Measure E and all of the other measures. When you look at candidates, however, it was really 50-50 in terms of whether the consultant spending did help candidates. And just really quickly to show you some more of the details, this is a list of all of the consultants, and you can click on them and get information in a pop-up table specifically about which candidates gave them money and what that money was spent for. So I'm going to pass it on to Jeff now. He'll talk about lobbyists.
All right, thank you. So this is one of the little sections in the chapter about lobbying data, and what you'll see right here is a word cloud. And I imagine you're probably familiar with the word cloud. But essentially, each word, the size of the word represents how often a contact from a lobbyist was made in association to that purpose. So it becomes really clear to the user which subject areas are being lobbied in the city, and so if you choose one, for example, housing property tax. On the left-hand side, we'll see the official who's contacted the department, the lobbyist firm, in fact, also the lobbyist client. So we can start getting a really pretty in-depth picture at what's happening. And then on the right-hand side, in the blue there, it actually says whether or not it was an effective lobbyist contact, or if it wasn't, if they received the outcome. So we can really start getting an interesting picture at what's happening in the city and what is effective.
Okay. We also analyzed the activity of political action committees. So I'm just going to show you a few highlights from this particular analysis. When we do ultimately get it up online, you'll see that there's much more than what we're showing you right now. But this is a visual that gives you information about who gave to political action committees and when they gave. So at the top here, we have a timeline showing all of 2014 from January to December. And what's interesting is you can see in May, there's a peak in contributions. That's right before the June primaries. And there's a higher peak again in October, right before the November general election. This timeline is interactive. You can click on it. And by clicking on it, you will activate the bubble graph down below. That bubble graph below shows you everyone who gave during that month that you clicked in the above timeline. You can then click on the names in the bubble graph and see more details about who gave to them. So, for example, Local 2 is a union, so you have individual names. These are union dues. If you look at something like Committee for a Brighter Future, you see a variety of corporate donors. So this allows you to look at contributions to political activities over time and drilling down into the specific individuals that are giving to them. There's also information in this analysis about what these political action committees are doing with the funds that they receive. So there's information about contributions to committees. So these are further detailed. If you click on the bar graph, you can see the political action committee, who the recipient committee is, and how much. So hopefully this will be a straightforward way for everyone who's interested in learning about political action committees to see exactly what they're doing.
And the last section of our analysis that we're going to show you this evening is about our county central committee data. And we couldn't leave here this evening without making sure you saw a map. So this is a map that we've created. And this map and those different pie charts represents the different contribution amounts to the different county central committees, specifically the Democratic County Central Committee, the Republican County Central Committee, and the San Francisco Green Party. But the reason why this is all kind of interesting and fun to look at is we can see that based upon the map, we can see outside source of funding going into the county central committees, so we can start understanding where some of the outside sources, players are coming from. Let's see, and then also sorry, I didn't mean to interrupt, stall there, but the map is interactive, and you can't really see on this right now, but there's supposed to be a map of actually also shows different states. So we have funding from Oregon, Colorado, and also Texas. So users can actually zoom out, zoom in, and start really looking at what's going on. So with that, that's essentially what we have to show you this evening. Of course, we're excited to really get the. Obviously, we can see it's a little glitchy, and maybe that's our own fault, but that's going to be solidified out. Yeah.
Yeah, so this is a preview. If you have any questions or thoughts about how this could be improved, we look forward to hearing them. And we'll take any questions.
Thank you very much. A very impressive presentation. Do any of the commissioners have any specific questions?
Yes, I'd like to echo what the chair said. This demonstrates an enormous amount of work on your part. For one thing, you've covered a gigantic survey of information and pulled it all together in a wonderfully comprehensive way, which is certainly going to be very beneficial for our staff in regard to the meat and potatoes of what they do on an everyday basis relating to what these matters affect, and also to the public who want to see who's doing what and whether something's on the level and what's not. So this is really a big contribution to city government, and so I want to compliment you on it. I just have one general question for you. I mean, you've covered all of this stuff, and is there anything that you take away from this that you would say that was something really dramatic that hit you, that you'd want to highlight, say, more than anything else?
Sure. I couldn't help but notice how much expenditures on Measure E really dwarfed everything else. And I didn't mention this in the analysis. You'll see it when you get the opportunity to look more closely through it when it goes live. But there was $12 million spent on campaign consultant activity this year. And in previous elections leading up, there was no more than 2 or 3 million. So it was really 4 times greater this year. And that's probably an aberration. Next year may settle back down to normal again, but we won't know and until that happens. So I do think that you see some very interesting trends each year, depending on what the hot button issues are. And those will certainly show up in an analysis such as this.
One thing I want to say maybe is a little less about the analysis, but also just about the process, really being able to see what information is out there. This information is already public, but the public doesn't have necessarily the tools or the understanding of how necessarily to put this together, and this just really highlights how important this is. And also, one thing we noted too, as we were working, for example, the consultant data, that's actually manually entered, and we realized that electronic filing is so important because it just allows, without electronic filing, we wouldn't have been able to do this today. So, that was one thing I wanted to note too.
Commissioner Hand?
When is this going to be online and usable by the public?
Probably within 2 or 3 weeks, I'd say.
I have to say that the visuals really make it easy for anyone to understand, and that is just so powerful. So your work is greatly appreciated. It's fantastic. Thank you.
Thank you.
Yeah, thank you. And I also just want to thank Steve and Jesse for really guiding this project forward. So thank you.
Commissioner Andrews?
Kristen and Jeffrey, really impressive work, and I, as a person who learns visually, this helps me so much. What was interesting to me when you got to the word cloud, and there may be more that will be shared or analyzed around it, you can see clearly there's a benefit to spending money on a campaign. Spending money on a campaign can get you to win. I wanted just to see if there was a more strict definition you could give around the word cloud, and if there was any correlation between the more educated the person was around that particular issue, meaning reaching more people and the word obviously being large, did that campaign win? Were there some campaigns that didn't need a lot of money but got greater education, or maybe the word itself or the concept used more, so that if I were driving a campaign that was around a particular issue, I would want to know, is it better to educate and direct my dollars around the education component of it, or is it better to go down another road of like ads or create a counter argument to it, or what really is the benefit of?
You're giving me a really good idea for another analysis right now. I think what we could do is we have information about independent expenditures. Some of that is here. I didn't show it tonight, but it will be there. We could do something where we could look at the amount on independent expenditures, and that's where you get into, was it on a phone bank, was it on an advertisement or a radio ad or what, and then see how those expenditures correlate with winning or losing elections.
Yeah.
That could be done. It hasn't been done yet.
Yeah, very interesting. Thank you.
Let me ask a question. Once you get online and you start getting new information as the election season is going on, how much time is that going to take to somebody keeping it up to date? In other words, it's great that you have volunteered and you're donating your time as interns, and I'd be delighted if you wanted to keep doing it. But I'm just curious as to how big a job is it to keep it up to date?
Well, that's a great question, and I actually have a great answer for you. Because essentially what you can do is you can embed this into the open data portal itself and use what's called OData, and that will link. So we would embed what we've done. Our report will be embedded on a website, the San Francisco Ethics Commission's website, and then we can link that to the actual data that is coming in. nightly, essentially. I think almost for everything, pretty much nightly. And so it would essentially take one day for it to always be up to date. However, except for the information which I kind of mentioned earlier, the stuff that has to be manually entered, that's the only thing that that's the only kind of missing link within that. But you know, there's a really it'd actually be completely doable to do that.
But does that mean that some staff employee has got to be doing that?
Yeah. You know, either a staff member would have to, manually input it, or you maybe put a mechanism that can for electronic filing, or something. But whatever would be determined by the commission.
Any public comment?
Hello, I'm Larry Bush from Friends of Ethics. I just have a few questions about drilling down information on this. If you were trying to search, for example, on whether or not a donor was an officer in a company, that's not easy to do because we don't use standard language for everything. So sometimes it may be CEO, other times it may be president. Is there any interest on the part of the Commission in standardizing the categories of employment that someone has to make that kind of search easier, as long as you're dealing with this? Secondly, when you're drilling down, can you show where the donor lives so you can tell X number of donors are living within the district where the candidate is running and X are not? That kind of thing. Then a third thing is whether or not a donor is employed by a nonprofit or in the case of a ballot measure, is a nonprofit. It's that kind of detail that I'm sure will emerge over time. Thank you.
Any other public comment? The question raised by Mr. Bush is what kind of information is there insofar as a donor that's in our database?
We do have information about the employer and job title of donors. However, those are open fields. They're not boxes that you check. So you were absolutely correct in saying that it's not standardized. I did look at that to try and see if there was any relationship between certain types of employment and a tendency to give how much to certain candidates. But it was difficult to pull together and to really make sense of at this point.
Thank you.
I don't know if you looked at that.
Yeah, no, the only thing I would add was, I guess, why some of the locations may be on there, I guess you want to raise the question of whether or not you would want to publicly, place people's independent addresses on there. I'm not sure if you would. Maybe, that'd be for someone else to answer.
Any commissioner have any other questions? All right, well, thank you very much for the presentation, and thank you for the work that you're doing. And we look forward to that going active. Thank you. Item number 4 on the calendar, discussion and possible action on public finance report. After each election cycle involving publicly financed races, staff makes a report on execution of the public financing program for that election cycle. At this meeting, staff will present a report on the 2014 election cycle. Who's going to make the presentation on behalf of the staff?
Well,
okay, thank you.
Hi, so this is Shaista Sheikh, Assistant Deputy Director, and the public financing report summarizes the supervisorial elections that took place in 2014. So it's a subset of the data that you just heard about. So in 2014, the 5 even-numbered supervisorial districts were on the ballot, and an incumbent was involved in each of these 5 districts. And initially, of the 17 candidates who ran for office, for supervisor, that is, 8 expressed an interest to seek public funds, but only 2 applied for public financing. And upon further review, I realized that the other 6 had not met the qualification threshold, and thus they had not applied for public financing. The two candidates who qualified to receive public funds ran for office from District 10, and they received a combined total of approximately $195,000. And from the time that the public financing program was first implemented in 2002, several changes have been made to the program. Changes such as changes to the qualification threshold, changes to various deadlines, changes to the amounts that somebody can receive, and the formulas by which we disperse the public funds. So because of these changes, it's very difficult to identify any patterns that could have resulted from public financing. And the report contains detailed information about the amounts of money raised by the candidates, spent by the candidates, including third parties. But because there were incumbents involved in each of the 5 races, third-party spending was relatively low in 2014 in the candidate races as compared to candidate races in prior years. If you have any questions, I'd be glad to take them.
Any commissioners have any questions on the report? Which I thought was very thorough.
I'm just curious because it's so dramatic that the two candidates who applied for public funds did get some hefty amounts, $135,000 in one case and $59,000 in the other. They didn't win, but they got those. What were the factors in terms of the conditions that would have kept the others from going ahead and applying? I mean, I just thinking as a candidate, if I were a candidate and that kind of money were available to me, I'd dive on it. So what's going on there?
So in order for a candidate to be eligible to receive public funds, the candidate has to show that he or she is a viable candidate and show that he or she has raised a certain amount of money in qualifying contributions. And the threshold in the supervisorial program is that a candidate has to show a non-incumbent candidate. That is, the threshold is higher for incumbent candidates. So a non-incumbent candidate has to show that he or she has raised at least $10,000 in contributions from at least 100 individuals who live in the city in amounts ranging from $10 to $100. That's one of the criteria, and I think that's the main criteria. The other criteria include things like you have to be running for the office and be eligible to hold office if elected. You need to have turned in all your forms on time and met all the required deadlines and so forth.
Thank you.
Sure.
Any public comment on the report? Hearing none, thank you very much. We'll move to item number 5, discussion and possible action regarding a proposed amendment to Commission Regulation 1.142-2, which would allow staff to implement an electronic filing system for candidates participating in the city's public financing program. Jesse?
Hi, Commissioners. Jesse Minardi, Deputy Director. So this item concerns a small change to language in our regs with a potentially big impact, which is, as Commissioner Rennie stated, would allow for the implementation of essentially the electronic submission by candidates seeking public financing of the required records. So as Scheista was mentioning earlier, you have to submit proof of receiving a certain number of contributions to qualify for public financing. And then after you qualify and you want to get matching funds, you have to again have proof that you've accepted a certain number of contributions of a certain amount from folks in San Francisco. So currently this is can be done electronically, but again through email or to go back to the late 90s, a floppy disk. And so what this would do is this would allow us to use a new system which was created by our vendor, NetFile, so that folks could enter it in directly, and it would also subsequently help them in creating their campaign statements that they have to file afterwards. So we do have Stephen Massey here who can probably answer the specifics with respect to the technical issues, but it's a small fix that will, I think, be helpful for everyone.
Why does it why does it have to be an amendment? What is there in the present section that would preclude doing that without an amendment?
Well, it just specifies now that it has to be, well, what we are hoping to do is, well, we need to be able to designate and tell people that they have to file this way, essentially, and that to the extent the reg doesn't change, somebody could legitimately say, I'm just going to send it to you via email. And so we thought it was wise to say, okay, look, we're going to have you do it in the manner designated by the commission, and that way we can actually roll it out slowly depending on sort of who's applying when. But right now people could submit it on floppy disk and we would have to take it.
So the hope is that at the end of the day that they will be required to do it this way.
That's correct, yeah.
And if they are, will that make it easier for the public to access the information?
Yeah, that's correct, yeah.
In what way?
Well, do you guys want to?
All of the qualifying contribution forms and the various administrative forms that come across electronically will be instantly posted to our website. Right now, they're all paper forms that are stored in our office. For some of the information, you'd have to come in and request it. But I would say that the greatest benefit of this will be really the efficiency of how we process these forms and the efficiency for the campaigns who right now, if you are a public financing candidate, you essentially have to do the record keeping twice for all of your contributions. You record it once for the public financing process and then you do it all over again to disclose the information on the state forms. So this will allow the campaigns to do it in one step and submit it to us electronically.
Thank you. Any of the commissioners have any questions they wish to ask? Any public comment? Do you want us to make a motion to implement, have the staff implement that proposed amendment?
That's correct. I think it would just be approving the proposed language that's on that's in the regulation.
Okay. All right. Anybody want to make a motion?
So moved.
Second. All those in favor? Aye. Right. Going to item number 6. Discussions and possible action regarding potential additional amendments to the San Francisco Campaign Finance Reform Ordinance. And I take it, Jesse, you'll be responding to that?
Yes, sir.
Right.
Commissioners, at our last meeting, the Commission approved a package of proposed amendments to the Campaign Finance Reform Ordinance. And during that conversation, a number of commissioners asked staff to go back and basically prepare a document that would facilitate a discussion at this meeting for potential ideas that might otherwise augment some of the provisions of CFRO, the Campaign Finance Reform Ordinance. And so what we did was we had some comments from interested parties, including the Friends of Ethics. We looked back at some of the past meetings and some of the discussions that the Commission itself has had over the past few years, and then took some of the Commissioners' comments and basically whittled down a bunch of ideas to about 6 ideas for presentation to you today, and then also for your discussion. And these are sort of some of these are bigger ideas than others, but we tried to provide a good overview, a balanced overview of what those ideas were, what we thought were sort of the main ones. And so I'm just going to sort of list them off now. The first.
I'm sorry to interrupt you.
Oh, no,
do you
please.
think it would be best to just do them one item at a time and then have discussion on that with the Commission and the public and then move to the next? Or do you want to do all 6 one fell swoop?
Well, certainly it's at the Commission's discretion. One of the things that I think the Commission should decide on is sort of what wants to focus on, whether that's, of these, whether there's one or two that's of interest to the commission, or whether all six. And so I think certainly having an overview so that the commission can have a sense of what's out there, because it may be the commission's decision that they're all good ideas, but we really want to focus on two or three. But I don't know. It's certainly up to you.
Commissioner Keene?
Yes, Mr. Chair, I think it would be best if we just took them separately, as the chair first suggested, and discussed them, because each one of them, if it is decided by us that we want to go forward on them, on each of them, because they're very discrete and in different ways, we'd likely want to make a motion regarding it. For example, like the first one, to actually put something on the ballot and discuss that, and then we'd do or not do whatever we would do on that one, then move to the second one. I think taking them all six together, it would be hard for us to make decisions between them as to what we want to do or what we don't want to do.
All right. Any of the other commissioners have thoughts on it? Well, I agree with your suggestion. I think we will take them one at a time. Sure. And I would propose that we will have the commission discuss and make a vote whether they want to say that's something that they would like to have done. And then we can prioritize.
Sure. Because
it may be we can't do all six. But then after saying we want to do all six, but let's put some priority on them, okay?
Great.
All right.
Sounds great. Thank you. Okay, so the first proposed idea would be applying the city contribution limits and bans to candidate-controlled committees that are not committees associated with a candidate or city officer's election. And the two examples we have here are ballot measure committees as well as general purpose committees. And so under state that are controlled by those candidates. So under state law, a candidate is deemed to control a committee if he or she has, it says, significant influence on the actions or decisions of the committee. And so we have had a number of committees, both, well, in San Francisco, but also outside the jurisdiction, that have been controlled by city officers, elected officers, and or candidates. And so this provision, or this idea, would essentially apply limits that otherwise apply to election campaigns for those city officials. Right now, there are no limits on those types of committees. So, for example, if a candidate were to control a ballot measure committee, they could raise and spend unlimited funds from, say, corporate contributors, whereas if that person were running for office, he or she would be limited to $500 contributions from individuals. And so this would apply the, again, the city limits and bans to any ballot measure or general purpose committee that the candidate or city officer would control. And I'm happy to go into more of the details here, but I think it's sort of laid out here, and I can certainly answer questions, as can Mr. Shen.
Any questions, Jesse, on that?
I don't have any questions. I would just, when we get to the discussion, I'd like to contribute to that.
All right. When you say get to the discussion, what, you want to discuss that proposal?
Sure. I do.
Let's hear it.
I think that this is a proposal that has a great deal of merit to it, and that we should go forward on it. And I would also note that one of the things about this commission that makes it unique as a body that has some power to really affect things in regard to the ethical situation of government in San Francisco is our ability to put things on the ballot. And I would suggest that we go forward with it in that respect with this one, because My prediction would be, I could be wrong, but I don't think we should let ourselves be led down the garden path by the chance of it. That if we just went in the way of putting it forward to the Board of Supervisors, to the mayor, there is a lot of political downside to this, to those who are actually in the political arena. And they're going to get lobbied against it. And there's a good temptation. Again, I'm not speaking against them. I'm just talking about the reality of politics. And for anyone who's a supervisor of a mayor, that they'd be very likely to say, no, let's not do this. So if we were to go ahead and just go forward with it in terms of approving it and asking the Board of Supervisors to do it, and then and having it go forward in the usual way for the mayor, I think we'd be somewhat Pollyannish, and particularly since we're looking at something now that to have it on the ballot for the November election, we have to do it within a fairly short amount of time. And the political process, the people in the political process can easily run the clock out on us. And this gets lost, like so many other things get lost that start out that are beneficial, and just inertia or whatever else, the bureaucratic process or memory fades, and it doesn't happen. So bottom line, Mr. Chair, is I would move that we go ahead and do this and do it in the form of a ballot measure that this commission puts forth to be on the November ballot.
I have a question of the city attorney. Do we have to, before we put something on the ballot, do we have to go through the step to the Board of Supervisors to see whether they will do it?
To the question about whether we need to forward anything to the board, no. Technically, the Ethics Commission could put it directly on without even consulting with the Board of Supervisors or any other elected officials. As a practical matter, you may want to for various reasons. Some of them may have input on the proposal. Some may have thoughts about ways it could be augmented, scaled down, et cetera, et cetera. But one other point that Jesse, I think, very helpfully makes in this memo, and I just want to highlight here, is that, and this is on the first full paragraph on page 3, Jesse rightly points out that, to the extent that we're enacting any new contribution limits or bans, those limits or bans would need to be substantiated by a legislative record, demonstrating that a genuine issue that raises corruption or the appearance of corruption concerns exists in the city, and that this measure would act appropriately to attack that concern. Now that, I think, would need to take place certainly before anything were placed on the ballot. So just to highlight that there would be a fair amount of work that certainly I'm happy to work with the staff on, but we would definitely need to put that together before we reach perhaps the ultimate step. And Commissioner Keene's reading may be absolutely correct as to what action may actually happen at the board. But whatever the next step is, I think we would need to sort of take a look at all the evidence and facts and assemble that record.
And I suppose the first step would be you've got to draft some proposed language that you want to adopt, that you want the public to adopt for purposes of putting this limit on contributions to these committees, correct?
Yeah, that's correct. I mean, I think we would start off with some proposed language. Obviously, that may be tweaked or amended as we go through a legislative record development process. The one other time that I'm aware of, at least, that the Ethics Commission has put a measure directly on ballot was with respect to Proposition O in 2000, which is the proposition that established the city's public financing program, where there was similar resistance at the Board of Supervisors level about putting it before the voters themselves. So the Ethics Commission went ahead and did it, but they also went ahead and did it after having a long series of meetings about what that public financing program should look like. There's various proposals, put forth. There's amendments. There's people invited to speak to the commission about the best ways to design such a program. A lot of things happened before that measure ultimately made the ballot and, of course, was adopted by the voters.
Any other comments, Commissioners, on this item? Any public comment?
Thank you, Larry Bush for Friends of Ethics. I appreciate this being brought to the Commission, and I think that Mr. Minardi has done a good job. I agree that a hearing that establishes a record that shows why there needs to be such legislation is critical. That should be an interested persons meeting as well as additional meetings of the full Commission. Friends of Ethics will be happy to participate in those discussions and provide whatever information we can. Just to give you a fuller context for this, it's only under the current mayor that we have ever seen a mayor establish a general purpose committee that essentially serves as an operation for bundling money from people who have city business, and then the mayor makes decisions about where to allocate that money in other campaigns. And we saw when he did that in 2012 that the first check was for $25,000 from Ron Conway, and it came within weeks of the mayor making a decision to adopt a new system of taxation that was of substantial financial benefit, according to the Business Times, to Mr. Conway and his various enterprises. The rest of the money that was raised was about $400,000, all of it in five-figure numbers, almost all of it from businesses that were about to benefit from a rewrite of the city's tax laws. So that kind of thing would have underscore why the question is raised. Same thing goes for members of the Board of Supervisors who would establish a ballot measure committee for a particular interest that they have, and they can accept contributions from people who are having decisions made by members of the Board of Supervisors. The memo here cites a few court cases, but it does not mention that those court cases do not involve candidate control committees. And so when we have an interested persons discussion, I think there should be an examination of the fact that Citizens for Clean Government, for example, and the Save California measures were not about candidate control limits. And secondly, in the case of the FPPC case, it was not on constitutional grounds that it was decided, but rather on whether or not the jurisdiction existed within the FPPC, which has a different kind of jurisdiction than the Ethics Commission in the County of San Francisco. Just so that you don't think that I'm pretending to be a lawyer without a license, this is coming to us from the Center for Legal Studies of Paul Ryan, who was the deputy to Bob Stern. And we have other people who will be happy to participate. So I recommend a process that involves interested persons and further meetings of the Commission, but I do think that it makes sense for this to go on the ballot and to establish greater public confidence in how money is spent to influence elections.
Any other public comment?
Good evening, Commissioners. Anita Mail, Pillsbury, Winthrop, Shaw, Pittman. Just a few comments. Imposing a $500 limit on contributions to ballot measure committees and PACs that are controlled by candidates or officers may raise constitutional issues. In Citizens Against Rent Control v. Berkeley, the U.S. Supreme Court held that although it is constitutional to limit contributions to candidates and their campaign committees, an ordinance limiting contributions to ballot measure committees unconstitutionally interfered with the First Amendment freedoms of speech and association. The court was quite clear when it stated the following: whatever may be the state interest or degree of that interest in regulating and limiting contributions to or expenditures of a candidate or a candidate's committees, there is no significant state or public interest in curtailing debate and discussion of a ballot measure. Placing limits on contributions, which in turn limit expenditures, plainly impairs freedom of expression. The integrity of the political system will be adequately protected if contributors are identified in a public filing revealing the amounts contributed. Thank you.
Thank you. Any other public comment?
Good evening. I'm Robert Van Ravensway. I was with the last civil grand jury. I think the staff makes a very important point about the importance of building a record. And I think as you get into holding hearings on this, you may want to get briefed by legal counsel on what potential legal challenges you're looking at and what sort of elements should be in the record. Because if you don't build the record beforehand, you hear what's going on. It's going to be in court. So you really want to build the best record you can. And this comes up both here and on another item you're going to discuss momentarily. And I think it's really important that you sort of get into the habit of building these records and everybody sort of knows what their role is in trying to put them together in terms of getting the right people to speak at meetings and eliciting the sort of information that's needed, and also building historical information as appropriate. Thank you.
Thank you. Any other public comment? Consistent with our earlier discussion, do any commissioners want to make a motion concerning this item?
Yes, Mr. Chair. I move that we go forward at this point and hold the necessary interested persons meetings that the staff determines are necessary to build a record relating to this, and that we, at our next meeting, pull that material together with our own building of a record here at our next meeting, with speakers who want to speak on behalf of it, with interested groups like the Friends of Ethics, Civil Grand Jury, other people who have been showing that they also believe that this is something that is good for the city and county of San Francisco. And my intention would be then, after that is done, if it then appears, as I think it will, that this is something that is beneficial, necessary, and that there is a sufficient record made to justify it, I would anticipate at that point then making a motion for the commission to put it on the November ballot. So right now it's sort of a preliminary aspect in regard to taking those steps to building that record with the interested persons meeting and then having it for full discussion at our next meeting.
Any second to that lengthy motion?
I'll second it.
Pardon me?
I'll second it.
All right. Any comments on the motion before?
Well, I only have a comment on we are moving forward. I'm in support of moving forward with it. I'm a little nervous about letting the November election somehow frame the work that we do. And if it turns out that we just run out of time because we really need to hear from all interested parties and we don't make the November ballot, I would not see that as a failure. I would just see that as the fact that we were doing our due diligence and making sure that we're coming out of the gate with all the information that we're needed to make the best decision possible. So to the degree that we aren't completely wedded to that timeline, I'm more interested in supporting the motion.
Yeah, my concern is based on what the city attorney's office described. I'm not sure that it's realistic to talk about doing it within time to get it on the November ballot, because it strikes me that the first thing we need some draft language of what the provision is we're proposing before anybody, either pro or con, can really start making presentations as to why it's necessary to adopt this language to avoid corruption and to make the political process more transparent. And on the other hand, for those who want to oppose it, for them to be able to be specific in the language so that I guess I envision it's more of at least 2 or 3 step process. The first being asking the staff to draft the language that incorporates what is talked about in this memo under item 1 and present that to us and get some agreement on this is language that the commission believes should be adopted, and then set up a campaign to support it and let those who oppose it set up their campaign and make the record that we have to make in order to meet any legal challenge that might come down the road.
Mr. Chair, you and Commissioner Andrews have both convinced me of the merit of what you said, and that my initial sort of rush for this towards the November ballot mainly comes from a certain wariness about the idea of we put something off and it never happens, or we just say, well, we'll do it in due time, and due time seems to never occur with so many things. But I think in terms of our discussion, we're all seem to be pretty much agreed that this certainly merits consideration and a record that would then allow it to be on a ballot if we find that it has that worth. And I agree that it's better to do it correctly rather than to rush. So with my confidence in terms of hearing my fellow commissioners that we are indeed going to go ahead and pursue this, I'm to pick up on what Commissioner Andrews said. I don't feel we need to be wedded to the November ballot, but to the idea of putting it on the ballot.
I can call your motion, or do you want to restate a new motion?
I think it's the same motion, but rather than any definitive language I had in there about the November ballot, it should just be that the commission put this on the ballot for the voters of San Francisco.
Second? Is that, again, you're seconding?
Second.
All those in favor?
Aye.
Aye.
Just by way of clarification, so for the next step for us is to bring back language for the commission to take a look at, and then we'll go from there in terms of building the record and presenting it to the public.
Right.
Okay, that's right. Great.
Yes, on the next, at the March meeting, there would be proposed language that you believe we should recommend to go on the ballot, and we can then, at that point, take the steps necessary to get it going. Great. All right, item number 2, which is fundraising and/or bundling reporting.
Yes, so Commissioners, this proposal concerns the disclosure of fundraising and/or bundling activity by individuals, primarily those who are not lobbyists. Fundraise because under our current laws, city lobbyists already have to disclose this activity. This would sort of broaden the reporting obligations so that individuals who aren't lobbyists would have to disclose one and/or two things. The first being bundling, which is generally the sort of collection and transmission of actual campaign contributions to a candidate. And then the second being fundraising, which is a little more broadly defined to include sort of hosting a fundraiser, making solicitations, even if the individual does not, him or herself, actually receive the checks and pass them off to the candidate. The idea is basically that while we have contribution limits in our city and county of San Francisco, a lot of influence, perhaps undue influence, can be exercised by virtue of collecting other checks and delivering them to candidates. So this would require the reporting at a certain threshold, we would say, of the bundling activity, and there would be a couple of decisions that the Commission would have to make if it decided to go forward. One is sort of what is the appropriate disclosure threshold in terms of the amount. The second is who would actually do the reporting, whether the reporting would be done by the bundler, him or herself, on a separate form, or whether the campaign that was receiving the money, the candidate, would be reporting who that bundler is. And so these are some of the issues going forward that the Commission would have to decide.
Any discussion, commissioners, concerning this particular proposal?
Well, I hate to monopolize the meeting, but I would. This one also is something that I would recommend that we go forward on. Obviously, it needs a fair amount of crystallizing and defining as to what it is we actually want to do. And I think in terms of what Mr. Minority proposed, he said that I think there were three things that first had to be determined as to what it is that we would want to do relating to fundraising and or bundling. What I would like to keep this one going forward, not with the kind of the first one I would certainly give the greatest priority to, so Mr. Minority has listed them quite well in my respect. But I think we ought to also go forward in regard to the question of bundling, because bundling, I think, has tremendous problems relating to the appearance of corruption in San Francisco and other places as well. And I would ask that the staff recommend to us some language that we could use in enacting some some regulations that would address the bundling problem with some teeth in it, and take into consideration the concerns that Mr. Minority put forth. I think at this point, we're not in a position to be any more definitive than that. If we were, I hope that's not too vague what I've suggested to the Commission, and I hope the Commission would see fit to go forward with that as well.
Any other comments? I'm curious now, under the present system, only lobbyists who bundle checks, in other words, that collect checks and deliver them to the candidate as a group, are the only ones that are banned from doing it?
They're not actually banned. They are required.
I mean, they've got to report.
They have to report, and it actually is the broader definition. So it's fundraising. So it's not just the delivery of checks, but it's the raising of money for candidates has to be reported. And just actually, these last few months, we've started to see, I think, based on the regulations that we passed in the summer, a lot of reporting of those contributions. So this would expand it to other persons. It wouldn't expand it. It would impose a new requirement for other persons.
What was the theory behind imposing this on lobbyists only? In other words, why were they picked out as opposed to Jane Doe, who holds a house party for a candidate and collects a lot of checks?
Well, this was originally under I believe the lobbyist ordinance that was enacted in 2010, and my understanding generally is that you would impose these requirements on lobbyists, certainly because they are in a position to be asking officials to be making particular, decisions, governmental decisions. And so the risk of the quid pro quo corruption is particularly great there, in that, we want you to please do X, Y, and Z, and by the way, I'm going to have a fundraiser for you 2 days later, and we're going to give you $20,000 for your campaign.
But that would seem to say that if we were going to expand it, it would require that the bundler have to be someone who is some way seeking favors from the city. In other words, there are a lot of individuals who support candidates who hold fundraising functions who never lobby the city, aren't doing business with the city, but they like the candidate. So I guess the question is, why should they be required to, if they don't have any connection with any kind of business and no quid pro quo, it's only a support for the candidate?
It's a good point. I guess I would say that this is, first of all, a disclosure obligation as opposed to a prohibition. So it would be, providing information to the public. We would want to have some sort of threshold, I think. So to the extent, somebody raises $500 for a candidate, it's probably not very important to the public to know that. But I get, one of the things is the potential for future action that the bundler may or may not be interested in. So while a bundler certainly may not have anything before that official presently, it could be that in the future that they do. So, but you raise certainly an interesting point, and as we point out in the memo, I'm unaware of any jurisdiction that requires reporting generally, not tied to, say, a lobbyist, which is what we do here and what they do at the federal level.
Because I in my other life, I can remember clients who were real neophytes in the whole political process, and they would have a favorite candidate because they went to college with them or they knew him, and they would hold functions, and they'd be totally unaware that there was some reporting requirement. And then somebody would say, hey, you violated that reporting requirement, and they, that's the problem, is that if you make it too broad, you're going to capture people who are not that familiar with the whole process. Lobbyists are. People doing business with the city are.
Absolutely correct, and we are not in the business of playing gotcha. I mean, one option for the commission consider would be to impose the requirement on the candidates. I mean, that's the other thing. So the candidate, if he or she is aware that a certain bundler has raised, just saying $10,000 for him or her, then is required to indicate in some way on his or her campaign reports.
That's what I was going to say.
All right. Any public comment?
I'm Larry Bush from Friends of Ethics. We are among the people who brought this issue forward for a number of reasons. We saw that there were contributions that were being arranged by city contractors who are not allowed themselves to give money, but who can put a check or raise money from other people for a candidate who will decide on their contracts. So we asked the question of the Ethics Commission of Mabel Ng, who was then the deputy director, and she said that is a loophole in the law, that there is no prohibition on people raising money who are city contractors and who may not themselves give money. We notice in some other jurisdictions there are rules that say that a city commissioner may not raise money for the people who appoint them, sort of a pay-to-play politics going on. So your point about saying that the universe that should be captured are people who have an interest in a city decision, whether it's an appointment, a permit for development, a lease or a contract is on point. I don't know in terms of what Mr. Minardi says about future interest and whether you would say if there's going to be something in the next 12 months, you would include that in the universe. But in a general sense, I think that we do need to close this loophole in part to respond to public cynicism that there's too much ability to influence decisions by fundraising.
What did you think of Mr. Minardi's suggestion that if you made the candidate identify any bundler who had collected money for them, wouldn't that then satisfy the requirement that one could then start saying, does that bundler, is there some connection?
I think that's a good step. I know in the last mayoral election, the San Francisco Examiner asked mayoral candidates to name the members of their finance committee. And the candidates said, we're not required to make that disclosure, so we're not going to. So that goes right to the point of whether the candidates should be making the disclosure.
Okay. Any other comments?
Anita Mayo, Pillsbury Winthrop. Just briefly, this second proposal, as you know, would require individuals who engage in a certain level of fundraising and are collecting of contribution checks for candidates to file public reports disclosing such activity. Prohibiting such activities would impact First Amendment rights, and imposing reporting requirements on such activities would create additional burdens on those exercising their First Amendment rights. If you decide to impose such reporting requirements, I recommend imposing the requirements on the recipient candidates and committees who are already filing reports and not the donors.
Thank you. Do I hear any motion as to how we should proceed as to 2?
Yes, Mr. Chair, I move that we request the staff to go forward and to come back with us, to us with some language relating to the regulation of bundling that will keep, that will be sensitive to the concerns of just not picking up some innocent member of the public who has finds a candidate having an appeal and has a fundraiser for him, and that it be to that end to link the bundling regulations in with the requirements upon candidates, and also perhaps also link it in with what we're going to be taking up in item 4, the matter having to do with public benefits, that the person who is doing the bundling is someone who might be interested in some sort of quid pro quo, just so that we don't burn the unwitting good government person who decides to back a John Smith, a Mr. Smith who they want to send to Washington.
Second that motion? Second. All in favor?
Aye.
Aye. Opposed? Motion is carried. Let's turn to 3, which is enhance private right of action.
Commissioners, just by way of clarification, so maybe at the end of our discussion, we could talk about sort of the when and that.
Absolutely.
All right, great.
Sure.
Okay, thank you. The next item has to do with enhancing the current private right of action that's found in CFRO section 1.168, which allows a voter to sue a city candidate or committee to force compliance with CFRO, so long as the commissioner or the city attorney has decided not to pursue an enforcement matter. So this recommendation was made originally by the San Francisco Civil Grand Jury this past year. And the general rationale for it is that it would better incentivize potential plaintiffs to enforce CFRO violations. And folks have pointed both to the city of Los Angeles as well as at the state level where potential plaintiffs can be entitled to recovery of up to 50% of any penalty that's eventually imposed. Right now, there is no the current section does not contemplate that the plaintiff would get any potential penalties, although it does provide a significant incentive in allowing for attorney's fees. So that is the general proposal, and the staff would only note that we did talk with folks both in Los Angeles as well as the state level, and it is these provisions are not frequently used in either of those jurisdictions. They are different jurisdictions. So that's the idea.
Any commissioner have any comments?
I have a question.
Commissioner Haynes.
So at this time, no one can sue under these circumstances. It's prohibited. Is there language that says it's prohibited?
No. As a matter of fact, somebody can sue. They have to essentially sort of run it by the Ethics Commission and the city attorney first and sort of give us first shot at enforcing one of these potential violations. But assuming the city attorney says and the Ethics Commission say, no, we're not going to do anything, then a plaintiff can go out and sue to sort of enforce compliance. So, this is all hypothetical, but, there's a committee out there, or there's a group of people out there raising and spending money on, an election they're not reporting anything for whatever reason, the city attorney's office, and we're not interested in enforcing it. A private plaintiff could go out, sue them, and seek injunctive relief so that they would actually have to disclose everything, and if they won, they would get their attorney's fees.
That is the situation at this time.
That's correct.
So therefore, why do we need to enact an amendment to CFRO to enhance their right to do that, if they already can do that?
Well, I think the rationale is that right now you would just get attorney's fees, but say, for instance, they were in violation of the law. The proposal would allow the plaintiff to get half of the penalties that were imposed. So say, again, somebody failed to report, they were fined or they were subject to a penalty of $50,000. That plaintiff then would walk away with $25,000 in addition to the attorney's fees if they're successful.
Other comments? Any comments from the public?
I would just make 2 points. You're correct that the right to sue does currently exist. This was something that was pointed out in the budget analyst report of a few years ago that the Commission had hearings on and responded to. But at that time, the staff report to the Commission merely mentioned that there is a right to sue in San Francisco and did not mention the comparison, which was the budget analyst comparison with Los Angeles, where there is a recovery of penalties as well. 2 things about the recovery of penalties. One is that it puts a timeline for the city attorney and the district attorney to come back and make a decision about whether they're going to act. As you know, we've seen cases that have gone on for 2 or 3 years without ever going back to the person who filed the complaint saying, yes, we're going to act, or no, we're not. With this, they would be required to come back and say that under the current rules, I believe it's within 14 days, the Commission has to go back to the complainant and say, we're going to take it up or we're not going to take it up and so forth. You might make it for a longer period of time since 14 days is a little fast turnaround for most legal procedures. But I think you're hearing a case tonight that's 4 years old. So these things do have a tendency to drag on, and when they drag on, the public loses confidence that there's real enforcement. So the timeline is one thing. And the second thing is that you do want to have a threshold that's reasonable. In California, at the state, the Secretary of State, acting Secretary of State, Tony Miller, when he left that job, made something of a living filing complaints about Form 700s not being filed. And finally, the state said, wait a minute, this is cluttering us up and it's really penny ante compared to what the real issues are. So they changed the standard. And you might want to look at that to see what the standard should be. But I think that there is some value in having a sort of Damocles that hangs over enforcement. Because, frankly, San Francisco's reputation for enforcement is not high. Not if you talk to the FPPC, and not if you talk to any other region, not if you talk to Ann Ravel, who was head of FPPC here. Thank you.
When we discussed this in the civil grand jury, it also came up in the context of looking at Proposition J that you're going to discuss on the next item to some extent. And that had a fairly strong private right of action that went away. It allowed any person to sue in local courts to enforce the Prop J and to recover 90% of the money would go to the city, 10% to the person suing, and they'd get attorney's fees as well. So that was a much stronger right of action, private right of action than now exists in San Francisco Ordinance. Thank you.
Anita Mayo again, just very briefly. Amending CFRO to permit recovery by any voter of a certain percentage of any penalties imposed on a defendant would appear to give an impression of something other than wanting to ensure compliance with the law. Enforcing compliance with CFRO should be the primary role of the Ethics Commission, the city attorney, or the district attorney, and not bounty hunters.
Thank you. Anyone want to make a motion in connection with the enhanced private right of action? Hearing no comments, I think we'll pass that one at least for now. Now, the fourth one is contribution bans for persons receiving a, quote, public benefit, close quote, from the city.
Thank you, Commissioners. This proposal was, as was mentioned before, put forth originally by the civil grand jury in its report last year, noting that there had been Proposition J, which had been passed by the voters in 2000, which essentially, and I'm speaking very broadly here, took what we have as the contractor ban. So there's a ban currently on folks that are negotiating contracts. Those folks are not able to contribute to city officials who are approving those contracts for a specified period of time. And that rationale really was applied with respect to a whole sort of list of benefits that folks might receive from the city, such as variances, tax abatements, special use permits. Again, the idea being that if somebody is seeking an official action, that they should not be able to contribute to someone who was sort of in charge of making that official action. And so this was part of Proposition J, which was in effect through 2003. And then Proposition E was passed, which essentially superseded Proposition J and sort of refined some of the prohibitions in Proposition J. And so the idea, my understanding, and the folks from the civil grand jury can speak to it more, the consideration that is before the Commission is to whether, not necessarily to reenact Proposition J, but to go back to that notion of banning contributions when somebody is sort of applying for a permit or a variance, et cetera, prohibit him or her from making contributions to the official who would be sort of approving that decision. So it's a pay-to-play rule. And, the only thing we would note is that there is, under state law, a limit on contributions that can be received by appointed officials, so not necessarily elected officials, but folks that are appointed to sit on a board or a commission. They cannot receive contributions of more than $250 from a party to a proceeding that they are hearing. And so that's the general summary. Happy to answer questions.
Any comments from any commissioner? Keene?
Yes, Mr. Chair. This is one that I would respectfully suggest that we also go forward with. The whole, I think something was lost when Proposition E passed, which was very valuable. And to target in on the main vice that we're talking about here, the whole aspect of pay to play in regard to someone who's going to get a public benefit, being able to give to the person who is making that decision, sort of goes to the heart of something that may well be corrupt or certainly appear to be corrupt, and has been the subject of a great deal of scrutiny and controversy in our city over the course of the last few years. So I would ask that we go forward on this one as well, and have the staff come back to us with some suggested language for again, a regulation that would have some teeth, not allowing the kind of pay-to-play that is suggested by someone getting a public benefit and being able to contribute to the person who is going to make the decision that they're going to get that benefit.
Other comment from any of the commissioners? Commissioner Hayden?
Once again, so a question. So under Prop E, the only thing that's in there is this so-called contractor ban. There's no public benefit ban.
That's correct, under city law. That's correct.
And why did it supersede Prop J?
Well, that was the express provision of Proposition E. In other words, what was put to the voters is we're going to take away everything that was Proposition J, and we're going to replace it with this more narrow, focused limitation. I mean, the one thing that, and I wasn't there, there are probably folks here who can explain it better than me, but it was true that at the time, Proposition J and the language that was enacted, that language was, as I understand it, drafted by a good government group out of Southern California. I think it was called the Oaks Project. And that language made its way into maybe a half dozen city laws. And there was a challenge down in Southern California to some of the language, and was actually, part of it was declared unconstitutional. I don't know for a fact, but I would imagine at the time this Proposition E, the superseding statute, was probably enacted in response, partially at least, in response to that court case and some of the constitutional concerns that came up down in Southern California. We looked
So this is an additional effort then to broaden out what's already in Prop E and to add the public benefit aspect to it.
This would be to go back, right? So it wouldn't be, so right now leases are covered, other personal service contracts are covered, but again, this would expand it to include decisions about permits, which aren't covered right now.
Thank you.
Yeah.
Commissioner Andrews?
As I understand the contractor ban, though, it isn't that you can never donate. Isn't it around something, and you would be using that language, right, which is within 6 months of whatever particular election cycle was, or so there's language that's around that. Is that the language that you would seek to mimic in this? Because there's an opportunity to donate. Timing seems to be the issue, at least with the contractor ban.
That's correct. With the contractor ban, it's from the beginning of negotiation through 6 months after approval of the contract. Similarly, with the state law prohibition really the limit of $250, there's a time limit there as well. So, and I think one of the problems with Prop J actually was that the prohibition lasted for a really long time. It was like 6 years in some cases. So we would want to make sure that the limit lasted for the appropriate amount of time. And then to go back to what Mr. Shen was saying earlier, because this is a limit and/or a prohibition, we would have to again build the appropriate record, which honestly will take a little bit of homework for staff because there's these are sort of complicated housing and tax issues that we'd have to sort of bone up on, certainly, but also just to find out that there is in fact a justification for this limit and for this prohibition.
And the only other thing that I would say, and I'm a little familiar with the contractor ban, is, and I think there's possibly some conversation that is being had. For example, for the nonprofit, it would be the executive director or the CEO who could not, but I think it also covered board members, which makes it a little troublesome because it's hard to keep track of all your board members' activities when they're not actually at a board meeting. So it does have an opportunity for one to fall down unknowingly, unwittingly.
Undoubtedly, that's correct with the ban, the contractor ban, and I believe under Prop J, it was contemplated that it would apply not only to corporate officers but also their board members. And frankly, enforcement it's a lot of record keeping because we're going to have to figure out what we have to find out who is actually applying for what permits and decisions, et cetera, when is it triggered, and then who are all the board members and individuals that might be covered. Because, again, corporations cannot make direct contributions to candidates in San Francisco. So the real prohibition is really on their directors and officers and owners.
Do you hear a motion in connection with item number 4?
Yes, Mr. Chair. I move that we direct the staff to come back to us. I'm sorry. I thought.
No, I'm sorry.
Just to come back to us with language that will address the question of someone who is receiving a public benefit from the city not being allowed to engage in contributing in or any other type of pay-to-play type activities that they're allowed to do now, that the public benefit aspect of the prohibition be put into to broaden the present prohibitions against contractors and other specific people who are in there now.
Second.
Seconded. I mean, I think we can take the first step.
Is
and
there
at least look at it.
public comment on this particular one?
Yeah, I'd like to make a few historical points. We actually had a whole section of our report on sort of the history of Prop J and its repeal. Prop E was a much broader rewrite of the conflict of interest laws of the city. And a number of those had been adopted by the voters, and they were sort of moved in certain ways where you would have the opportunity to amend them in the future by going through the Board of Supervisors, like you are with the campaign finance laws. So there was a whole number of moving parts that went into Prop E. The contractor limitations have been separate ballot proposals that were enacted, I think, first in the 80s and then again in the 90s. And Prop J was sort of, it wasn't an outside group from Southern California, and they had their own language, and it didn't really quite mesh with other language, and had, some other things it was raising. What intrigued us was this whole concept of public benefit. And then beyond that, if you look at the text in your package, there's findings and declarations that are very strong with it about the appearance of corruption and things like that in granting public benefits that just went away, and I think would really strengthen ordinances that are aimed at controlling corruption if they were back on the books, regardless of how the other text is worked with. And I think this concept of thinking about public benefits is important for thinking about how the flow of money can affect city government in negative ways. So I will forward you that section of the report for you to look at, but I think the history is a little more complicated than is being discussed at this point. Thank you.
Other public comment?
Larry Bush from Friends of Ethics. When this was passed as Prop E in the rewrite, there was nothing in the material that went to the Commission that explained that these provisions from Prop J were being repealed. There was also nothing that was told to the Board of Supervisors about that when they did the rewrite, nor was it in the voter handbook. So it really was under the radar that no one realized what was going on. And we know that because we have people who served on that commission who said, I had no idea that one of the impacts was going to be to repeal this. And we had members of the Board of Supervisors, like the president of the Board of Supervisors, who said, I had no idea that that's what we were doing on the ballot. When Mr. Ravensway did this section for the civil grand jury, he repeated the quotes that were from the voter handbook, from the Ethics Commission hearings, and from the Board of Supervisors, and there is no mention in any of this about repealing the public benefit prohibition. I think that it's worth noting that there was an earlier effort by members of this commission to repeal the section dealing with contractors that had to do with members of the Board of Supervisors, and they could not find a single sponsor at the Board of Supervisors. And I do not think that you're going to find a sponsor for that now. That's not the way that the atmospherics are at City Hall. It's even if it's not an election year, people understand what the dynamics are. But certainly when you're talking about things like Comcast or Recology or any of the other kinds of people who have special permits with the city, there are questions that raised all the time about the fact that their directors are on that. And in terms of being able to do a lot of research and work, we did it at City Report. I just hired somebody to go through the top 15 nonprofits because they were the easiest to go through. You go through GuideStar that lists the names of each of the board members, and you match them up on a computer system with who are donating, and you found that virtually every one of the nonprofits had board members who were making major contributions. And some of the contributions were significant, and some of the contracts were very significant. When we're talking about the top 15 nonprofit contracts, we're talking about people getting contracts that are over $10 million. So there's a reason why people have skepticism. I suggest that you guys take a look at what the facts are. Thank you.
Mr. Chair, may I ask Mr. Bush a question?
Sure.
Mr. Bush, you're more knowledgeable of the history of these things than many of us are. We listen to this and we hear that it seems like there was some sort of negligence involved, some major thing happened in regard to a prohibition against people who are getting a public benefit, that all of a sudden that just disappeared, and then everyone in positions of responsibility said, gee, we didn't know that was going to happen. Is that really what happened, or am I too conspiratorial in my thinking here?
I don't think that the people who voted on the commission or at the board were really aware of that provision, because Prop E in 2003 was very broad. It had a great deal of material in it, and what it essentially said was if you look at the record, it says we're going to come back to some of these things later, but of course they didn't. And the second thing it said is it's being moved over into part of the administrative code, which can then be amended by City Hall or by the Ethics Commission. And of course, none of that happened either. So it looked as though they were all process-oriented rather than result-oriented. And as far as the Ethics Commission staff who put this forward, I think I don't want to attribute ill will on the part of those people. There were some good people there. I think they thought they were doing the right thing and cleaning things up, and they got overly ambitious. In terms of Commissioner Andrews' question about the length of time after someone has a contract while this prohibition is in effect, this commission already voted 2 years ago to make the length of time 12 months, but nothing was ever sent then to the Board of Supervisors, and that was in a packet that I sent you all in the last month, a list of things that had been done by the commission but then were dropped in terms of getting to the board. So 12 months is what you already were on record as opposed to 6. Thank you.
Anita Mayo, Pillsbury, Winthrop, Shaw, Pittman. The fourth proposal would reenact many, if not all, of the provisions of Proposition J, which was also known as the Taxpayer Protection Act, a confusing ordinance which imposed prohibitions on campaign contributions and gifts to certain city officials from persons who receive public benefits, such as contracts, variances, tax abatements, etc. Proposition J required city officials to constantly monitor their gifts and campaign contributions to ensure that their donors had not received any public benefits. As staff has indicated, Proposition J was repealed when Proposition E was adopted by the voters in 2003. The Legislative Digest, which summarized the provisions of Proposition E, specifically stated that it would delete the Taxpayer Protection Act, which is Proposition J, and that Proposition E would accomplish some of the same goals by limiting gifts, future employment, and campaign contributions, but these provisions would be more narrowly tailored to accomplish those goals. In addition, the ballot argument submitted in favor of Proposition E by the Board of Supervisors stated that many of the city's current ethics laws were outdated, confusing, or don't adequately address the conduct they were intended to regulate. As a result, the San Francisco Ethics Commission spent the last 11 months analyzing and discussing these laws with members of the public, city officials and employees, and legal experts from across California. Proposition E is a result of that process. Based on the above, I urge that you not reenact any of the confusing portions of Proposition J.
Thank you. Any other public comment? All those in favor of the motion?
Aye.
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 Opposed? Motion is passed. Turning to 5, which is debarment as a penalty.
Commissioners, this proposal, the idea is to add a penalty for violations of the Campaign Finance Reform Ordinance, particularly for those who are city contractors. And so the proposal is debarment, and debarment would essentially prohibit persons who might do business with the city and county of San Francisco from doing so or from bidding on those contracts for a certain determined period of time if they were to violate CFRO or provisions of CFRO. And so this was proposed by Friends of Ethics and based, as I understand it, on a similar provision that was enacted by the voters in Los Angeles. So this is the general idea. The one thing that we would note, and we note in the memo, is a debarment penalty is certainly a serious penalty, which may or may not be warranted. But there are other interests that the city may have in terms of its own contracting process. Those are taken into account in Los Angeles. when the Ethics Commission down there considers whether debarment is an appropriate remedy, including sort of the severity of the violation, the effect, and this is important, I think, the effect of debarment on city services, finances, and legal obligations. The city attorney's office might be able to talk a little bit more about this, but there already is a debarment process under Chapter 28 of the Administrative Code. Any violation of the contractor ban certainly could qualify as a ground for debarment, but it's a different process that requires a charging official such as the mayor, the controller, or the city administrator. And again, in enacting, if the commission were to sort of pursue this idea, one of the things that we would strongly recommend is that we do interested persons meetings and also talk with city contractors and city agencies to understand sort of how the process might work and how these so-called mitigation factors might come into play, given sort of I think, you know, the example you would give is one $500 contribution made an error, and that violating a $20 million contract that's halfway to completion. You would want to make sure that there was sort of it wasn't disproportionate in its effect in terms of the violation.
Commissioners, any discussion on this? Is there presently a disbarment procedure in the city?
Yeah, I can speak briefly to that. Yeah, so as Jesse briefly referenced, there's a debarment procedure already established in the Administrative Code under Chapter 28. Now, it's not.
How does that function? Who makes the decision?
So there are certain charging officials, such as the controller, the city administrator, the city attorney, who can essentially bring the allegations to light against the contractor, essentially what the contractor did, usually in violation of either a contractual provision or some provision of city law, saying because you violated X, not only are we probably going to void the contract, obtain any monetary penalties, etc., but we're also going to prohibit you from a certain period of time. It's usually not a permanent thing, but 1 year, 2 years, 3 years, from which you cannot bid or seek city work. Now, what's currently the situation is that it is not explicitly linked in any way to the Ethics Commission proceedings. So if the Ethics Commission were to pursue something against a contractor, perhaps some sort of contribution limit issue, a contribution ban issue, usually what the Ethics Commission is looking for in terms of a settlement or some sort of penalty is purely a monetary fine. Now, the Ethics Commission could try to more affirmatively incorporate debarment as a term of agreed upon settlement. There's nothing that bars that. And certainly if there was currently some recourse to use the debarment proceeding right now, it would be a little bit unwieldy because it's not, again, explicitly linked with an Ethics Commission process. So hypothetically, the Ethics Commission could do the full hearing on the merits procedure, find a contractor had violated some contribution issue, for example. And then after that concluded, one of the charging officials designated by Chapter 28 could start a second separate proceeding where the result of that would be debarment. That's possible and practical and a little bit unwieldy, but that's also possible under existing law.
Do I hear any motion in connection with number 5? If not, any public comment?
Thank you. I'm Larry Bush for Friends of Ethics. Also, I spent 15 years as the Public Affairs Officer for the Department of Housing and Urban Development. And in that capacity, I saw a number of contractors with HUD who were debarred, because the federal government does have a debarment procedure. In fact, we publish a list of people who have been debarred from contracts. You can be a limited denial of participation or a full debarment. Full debarment is 5 years. Limited denial of participation is 1 year. It could be a real estate agent who misrepresented information to a client. It could be a contractor, or it could be a housing authority official who was involved. I think that debarment is a serious tool. I don't think that you would use it frivolously, but I do think that the Commission should have the authority to use debarment if it is warranted. Otherwise, what you're going to run into are cases where you have, for example, Archway Properties, which did money laundering and which faced penalties by the FPPC and the city, but then went on to still have city contracts. Why would you still give city contracts that are worth far more than the amount of money that was ever paid in a penalty, when in fact what you've done to them is fine them because they were robbing the taxpayers of the right to have a fair and honest election? So I think debarment is warranted in a number of cases.
Why isn't the administrative process that the city attorney just mentioned, why isn't that the way to handle it rather than through the Ethics Commission?
Well, the city attorney has done that, for example, with AIMCO, which was a multifamily property developer here in San Francisco. And they told AIMCO, we're going to debar you and take away your contracts with the city. And it forced them into a settlement of $20-some million. But that doesn't, that's a process that takes place outside of the public and doesn't really see that the public has an opportunity to make a complaint, have it heard, referred over, and all the rest of that. Plus, as Mr. Shin just said, it's a two-step process. You have to first have a hearing here, and then you have something that goes on behind closed doors, basically. That's my answer.
Okay, thank you. Any other public comment?
Anita Mail, Pillsbury, Winthrop, Shaw, Pittman. This proposal would add debarment as a penalty for violations of CFRO, particularly impermissible contributions made by city contractors. This penalty would disqualify a potential contractor from being considered for a city contract or other public benefits for a specific amount of time. Debarment is a harsh penalty, especially when applied to negligent violations of a regulatory scheme as complex as CFRO. Such harsh penalties should be reserved solely for intentional violations of the law, and the current penalties in CFRO are sufficient for negligent violations. Thank you.
Thank you. I guess we'll move to number 6. Oh, I'm sorry.
Good evening, Commissioners. Kevin Hennigan. I would speak against any proposal to add debarment into the CFRO. Commissioner Andrews talked about, which in my view is the most prevalent example of contractor violations of CFRO, is when you have a volunteer member of a nonprofit board of directors that happens to get money from the city, is completely unaware that their nonprofit gets money from the city or has a contract, and decides to support a candidate. And makes a $100 contribution to a candidate. The result of that would be a nonprofit that otherwise is doing good work for the city being debarred from getting a city contract going forward, and I think it's a bit harsh. It seems like the current debarment process would allow the city, and even perhaps upon the recommendation of the Ethics Commission, to go after the worst violators. Right? If you had a city contractor who was laundering $200,000 to a campaign or something like that. I would think that the current city process and the current, city officials would actually seek debarment in that situation. But to kind of have an automatic debarment or some kind of remedy in CFRO for kind of minor violations of the contractor ban, I don't think is appropriate. Thank you.
Thank you. Item 6 is slate mailer filings.
Thank you, Commissioners. This proposal, this idea concerns slate mailers, which are those mailers that you get every election season, which support or oppose 4 or more candidates or measures, and often are affiliated with parties, but also can be for-profit entities where the candidates or measures are often paying to appear on those mailers, and sometimes not. They are subject to their own sort of disclaimer rules that are imposed by the state, and in fact they are technically state organizations, and as such, file their campaign statements disclosing money in and money out with the Secretary of State, and file copies of their reports with the Department of Elections. So this is just sort of a technical change which would require the slate mailers, instead of filing them with the Department of Elections, to file them with us at the Ethics Commission, so that their activity could be accessed sort of one-stop shopping. You could see the candidate activity, but also then see the slate mailer activity.
Comment? Commissioner Hayes?
It seems very straightforward, and I certainly would support our putting that into effect.
Do you want to make a motion?
I move that we approve and that we endorse action to make that possible.
Second.
Public comment?
Larry Bush from Friends of Ethics. Just a point of information. While it does go to the Elections Department, to the clerk is responsible for accepting documents from all of Northern California, and they do not sort out the San Francisco submissions. And so therefore, they don't have a system that allows you to go in and find out what are the slate mailers that are going to San Francisco voters involving San Francisco candidates. By moving it to ethics, you do have that access. So it's really a public disclosure.
Any other public comment? All right. I'll vote on the motion. All those in favor?
Aye.
Aye. Opposed? Passed unanimously, 4-0. Now, we have gone through these items, and as I recall, if I recall correctly, items 1, 2, and 4 directed the staff, 6 as well, but 6 is a more straightforward, but directed the staff to take some further action. And I would ask Mr. Minari, how would you prioritize those? Because recognizing that there's a fairly heavy burden, where should we start?
Just give me a week. No, I'm sorry. What I was thinking as we were discussing this is that I know at the FPPC they used to do this. They had their regulatory calendar. So it might make sense. It seemed that the commission very much wanted us to get moving on item 1, which we certainly can do in terms of drafting proposed language that we would then, and then begin our IP meeting process and gathering the record. What we could do is come back to you with that language in March. We could also in March present a proposed calendar in terms of how we would go about doing this. I would recommend that we'd include in that not only this stuff, but there are 1 or 2 other things that we permit consulting stuff where it's very clear we have to do something in the next few months or so, that we sort of just put it together, package it together, and put a proposed calendar, and then you folks can certainly comment on it, and we can make modifications based on your input.
Well, if I understand what you're saying, are you talking about a calendar just for item 1 or a calendar for the other 2?
I think all of them, yeah. A general calendar with a, projected completion and timeline, that sort of thing.
Commissioners, do you have?
And following up on your language with the understanding that item 1 is the one that has tremendous priority for us as opposed to the others. The others we still want to see move forward with dispatch, but item 1 is something that we would like to see go as efficiently as possible.
Yep, that sounds great.
I fully support that timeline. I'd like to see that.
Have public comment on that proposed timeline? All right. Hearing none.
I think a calendar is a great idea.
All right. All right, we will look forward to March 23rd's meeting.
Thank you.
All right, let's turn to I think it's number 7, discussion and possible action regarding an amendment to the changes to the San Francisco Campaign Finance Reform Ordinance, which were approved by the Commission at its January 26, 2015 meeting. The amendment imposes the same font size requirement for disclosure on smaller written communications on both independent expenditures and electioneering communications. Comments, Mr. Minardi?
Yeah, thank you, Commissioners. As we said last month, the Commission approved a package of changes to CFRO, which were designed to standardize the reporting requirements for third parties making independent expenditures and otherwise spending on elections. Also included were changes to standardizing the disclaimer requirements, again, the messages that must be on the mailers that are sent out, and those apply both to ballot measure committees as well as to candidates, and also to so-called electioneering communications, which are communications where you're not advocating for or against a candidate, but you're just sort of mentioning him or her within the 90 days prior to the election. And we, I think, did a great job of standardizing those rules, but there was one omission that we caught afterwards, and that would just be that, and that's for small sort of printed materials, so like flyers and campaign buttons that are oversized, posters, those sorts of things. And basically we forgot to put the language in, or I did forget to put the language in. So this corrects that error so that independent expenditures that are subject to the disclaimer requirements and electioneering communications that are subject to this disclaimer requirements are the same, specifically with respect to these smaller items like door hangers, flyers, and posters. So this is just a cleanup, and we don't think this will sort of delay anything. It's just sort of a follow-up to make sure that we're all correct.
Any commissioners have any comments or questions? Public comment? Hearing none, does hear a motion to
Move that we accept.
Pardon me?
I move that we accept the amended correction.
Is there a second? All right, all those in favor say aye.
Aye.
Opposed? Passes unanimously. Item number 7, discussion with City Attorney's Office regarding potential litigation against local committees, including Common Sense Voters, SF 2010, vote for Mark Farrell for District 2 Supervisor for violations of local campaign finance laws.
Commissioners, I'd just like to note that I'm going to be recusing myself and stepping away from
right.
the commission at this point.
Any public comment on agenda item 8, including whether or not we should go into closed session? Hearing no public comment,
I think that
we want,
Is this public comment only about whether or not you should go into closed session, or is this about something having to do
on the
with...
item, you can, on the item itself or on
Okay, I do
closed
have a
session.
comment. Thank you, sir. I do have a comment about the item itself.
All right.
My name is Michael Garcia. I formerly was on this body. I was served on the Ethics Commission. I was president. Served on the Board of Appeals for the City of San Francisco, and currently I'm on the Citizens General Obligation Bond Oversight Committee. I am also currently, and have been for more than 15 years, an arbitrator for FINRA, which is a financial industry regulatory authority. And, hopefully I only bring that up to have you know that I sat where you sit and understand how awesome the responsibility is that you have and the decisions you have to make, and I respect you for that. I have a theory about this. I also ran for office, and I also had Chris Lee as a campaign consultant. So I feel somewhat intimately about this particular issue. I think the way I feel about it is that Mr. Farrell, candidate Farrell at the time, had a reasonable expectation on his part that campaign consultant Lee would act in good faith, that Lee would exercise a duty of loyalty to candidate Farrell and would use reasonable care to serve and protect his interests, Farrell's interests. This establishes Lee, as far as I understand it, and understand this area of the law, as Farrell's fiduciary. Through his actions, Lee not only violated campaign finance laws, he also breached his fiduciary duty to candidate Farrell. To hold Farrell responsible for the actions of Lee would be manifestly unjust. The FPPC, after 1.5 years or more, I'm not exactly clear on how long this process took, of investigation, did not find Farrell to be culpable. It did find against Lee, and in my opinion, to proceed with litigation against Supervisor Farrell in a 5-year-old action that should be barred by timeliness would be a waste of city resources, and worse, whatever the outcome of that litigation would be. I understand, Mr. Keene, you're an attorney, Commissioner Keene. I understand you're an attorney, Commissioner Rennie, and perhaps other people are here. We all know that if you go through litigation, whatever the outcome is, it can affect your reputation. And I think that's the most important factor to consider here if the city is going to consider whether or not to go ahead with this process and whether or not to even consider taking this to litigation. It could do great harm to someone who was found to be who was exonerated by the FPPC, and this procedure should stop. Thank you very much for your time.
All right, thank you. Any other public comment, particularly on whether or not the commission should go into closed session? Any commissioner want to express or make a motion in regard to whether or not we go into closed session?
So moved.
Second.
All right. All those in favor indicate by aye.
Aye.
Aye. All right. All right. We will then go into closed session.
assert Gov TV, San Francisco Government Television.
right here. What do you think?
I'll take it.
Huh? Yeah, that's what I'm talking about.
You're right. I don't need it.
That's why the food that comes out of this kitchen tastes good, because everyone is just nice and happy.
These are the things which world hasn't seen. We need more people who can support women like us.
And the goal is to provide affordable commercial kitchen space and hands-on technical assistance to low-income and immigrant women entrepreneurs who are launching, growing, and formalizing food businesses. La Cocina. We try to find people who are already selling informally. They apply for the program, they write a business plan through a partner organization, and then we work to formalize their food business through a series of strategies to get them to the point of economic or operational self-sufficiency.
My name is Andrea Klein, and I'm the owner of La Chita, an habanero oil and flavor enhancer. It's the only way I know how to say I love you. It's really hard for me to express in any other way.
I would say every single one of our entrepreneurs has an incredible spirit, an incredible passion for what they do. She moved to San Francisco and started sort of getting her life established here, but really with the idea to start a salsa company. It's like a habanero oil, which is not something you see on the shelf every day, and it really just adds amazing flavor to whatever you're eating. She gets people who claim not to like spicy food to taste habanero, which is not an easy feat, but I think really will serve her really well as she grows her business.
I would love for it to go national at some point, but like right now, I just wanted to see it on a shelf somewhere, you know.
Every business is connected with a logo, a website, get social media, you know, just sort of really get started in that sense. And then we also then work through product. San Francisco is full of really adventurous people who want to try new things, but it isn't always obvious to entrepreneurs who are just getting started how to reach those people and how to reach them and tell stories and talk about their food in a way that's actually going to be attractive to that new audience for their foods.
Over the last 10 years, we've really grown tremendously, and we now have people from all over the world. I mean, we're still mostly focused on Latin American immigrants. That's still the densest part of our program, and we have folks from Chile, we have folks from El Salvador, we have folks from Mexico, but we've also seen a lot of clients come from all over the world. So we have a Nigerian client, Ethiopian, Nepalese, Indian, Japanese. I mean, it's really incredible to be in the kitchen. I think there's something like over 27 languages spoken by the clients.
You're ladling out, you know, your lunch at some Whole Foods. There's actually Beanie's Food is there as some of the options, which is really exciting. Her dream is eventually to have a restaurant where she can serve all of these foods, but I think for now has really done a great job of scaling her business and growing it to a place where she'll be able to achieve that.
Hi, I'm Beanie. I'm the owner and a chef of Beanie's Kitchen. And thank you and dhanyavad. Hing, timor, cinnamon, black cardamom, and cumin, whole cumin, bay leaves. Because of the Beanie's Kitchen spices, I get authentic and traditional food to San Francisco. The growth and success is so much that it's hard for me to pick it up. And here, this one is vegetarian momo, one of the signature dish with spicy tomato cilantro sauce. And up there is rotis, which are layers of whole wheat.
Part of it is just training around how to use bigger machines, how to scale, where to source. And then we transition to operation, permits, legal advice, you know, when you hire people, what are all the different rules that you need to follow, really making sure that people understand what it takes to operate a food business. And then we also work with people on finances. And then lastly, sales. So really taking all of those different things that they've done over the course of incubation and translating that to a launch and to really being able to sell their food formally for the first time.
Buenas tardes, mi nombre es Isabel Pasos Velázquez y soy dueña del Buen Comer y hago comida mexicana y estoy muy orgullosa por haber llegado aquí y empecé a vender en mi casa y ahora voy a lograr mi sueño de poner restaurante. empezaba desde como a las 8 de la mañana y terminaba hasta las 6 de la tarde, pero yo empecé a ir los guisados con conocidos de México de nosotros. Fue como yo empecé a vender en mi casa.
There's food everywhere. And when people are selling that food, they're business people. And if they're succeeding at selling that food, they're successful business people. And so when someone like Isabel, when you hear about someone like Isabel and you go to her house and she delivers a meal experience to you that's as rich and as fulfilling as any meal experience you might pay tons of money for, I think that you have to think about why that person doesn't have the opportunity to do more of this.
Yo entré a la cocina en el 2007, en diciembre de 2007. El proceso del restaurante tiene más o menos como 1 año o 3 meses. Y no, bueno, mi idea nunca imaginé que fuera a poner restaurante. Pues yo pienso que mi negocio va a crecer por lo de mi comida. Al principio todo se me hacía difícil porque pues yo cuando yo llegué aquí nunca me imaginé de que fuera a entrar a la cocina y fuera a vender la comida que yo sé. Pero ahí en la cocina he tenido muchas experiencias porque yo aprendí ahí a cómo usar todo lo que hay dentro de la cocina, lo que son los hornos. Ellos nos enseñaron cuando nosotros nos llegamos cómo debíamos de usar todas las máquinas. La comida corrida, le digo que es comida que nosotros vendemos en México, bueno, que se hace en México y la hacemos bastante picosa, porque para nosotros si no pica la salsa no está buena.
I think that when people are in the kitchen and they actually get to chop and stir and cook, that's where, it's sort of all of the months of dreaming and planning really feels real, and it's really incredible.
I think the real story of La Cocina is not simply the organization, but it's the women who cook out of here. I think that we really actively believe that we are translators or conduits of success, and it's not us who empower. These women are already powerful. It's not us who help. These women are helping themselves. And so it's easy for us to tell a condensed story of La Cocina and much more difficult to follow the lives of 50 different women who have invested their time and hopes here. But that really is what makes this place amazing. I mean, the success of La Cocina is the success of those businesses.
Every step is a challenge. All challenges are welcome. I'll keep on rising and I'll keep on stepping on.
SF Gov TV, San Francisco Government Television.
Oh, it's just everything that's great wrapped up in one convenient package.
I don't know, it's just something I grew up on. Burritos are the best, man.
I just get the meat, rice and beans,
sour creams and cheese. I like my refried beans.
Oh, I love salsa verde with my burrito, but then obviously pico de gallo with the chips.
What more could you ask for?
Salsa. I like it kind of spicy.
Guacamole.
I love avocado. My dog's name is Avocado.
Every burrito I've gotten here is like too big for me to finish in one sitting.
With the mission-style burrito, you just get so much more. And who can argue with that?
I think that burritos are the quintessential San Francisco comfort food at this point. A mission-style burrito is very embellished and kind of oversized. It's got a lot more ingredients in it than a regular burrito.
When you're going to San Francisco, be sure to come to La Cumbre today.
Edward Duran and manager and proprietor at Taqueria La Cumbre. La Cumbre is a family-owned business. It's been in operation since 1967. The business was started by our founders, which were Raul and Micaela Duran. burritos for something different. And Raul thought, well, with a flour tortilla and Grandma's recipe for the flour tortillas, we could stretch out the tortilla and actually make something bigger and make something that provides someone with enough food to get through the entire day. In other words, it was kind of the equivalent of a brown bag lunch, but in a tortilla.
They're portable. It's not uncommon to notice a person walking up Valencia and they're chowing on a burrito as they're walking.
The mobility of the burrito is really the appealing aspect of the burrito.
I'm Patrick Cosere, and I'm the owner of El Faro restaurant. My wife and I bought it 8 years ago, and she used to work here in the 80s. It's a good food and it's a good price, and it's pretty big size, it's a pretty big meal. El Faro has a big history, probably the biggest history of any burritos in it. They've been here since 1961. At one time it was the only place where they made burritos in San Francisco. They said it was big lines, many people working here. The original owner started El Faro, Mr. Febronio, and he had 5 or 6 at one time. We've been trying to keep it the same as it was originally. That's why many people ask, is it the original owner still here? Because we try to make it the way it was before, you know. Well, I wasn't around. I really don't know. People here claim the first ones, and people on Valencia claim the first one over there.
Hector and Fabrono, the group that started El Faro, wonderful people. And when you start together like that, at that time, everyone knows everybody. And so, we all have our stories. They say they, we say we.
All signs point to a place called El Faro over on 20th and Folsom. Back then, this is in the early 1960s, it was a market, and a group of local firemen would come in regularly, and one day they wanted something besides sandwiches, so he whipped up sort of an enormous version of burritos for them. That's kind of where legend has the Mission-style burrito sort of having its birthplace. And then La Cumbre was the next taqueria to come on the scene later in the 60s.
I don't think it's possible to narrow it down to just one. There's a lot of great burritos out here.
Taqueria Cancun.
El Farlitos.
La Taqueria.
Papalote has always been one of my favorites, and the carne asada here is about as good as it gets in San Francisco.
Los Coyotes.
Taqueria Guadalajara has 80 different salsas.
La Espiga de Oro. La Cumbre.
My favorite spot is La Corneta. They have the best prawn burrito in the city, hands down. Come on, it's not up for debate.
El Castillito up on Church.
El Burrito Express out in the Sunset, that's where I live. They're pretty great, and they deliver.
I mean, in San Francisco, you can't go wrong. You're not going to go a week without hitting the taqueria like once or twice. It's kind of like a community center.
It's part of the fabric of the neighborhood, part of the fabric of the community. The burrito became kind of a go-to food for people who really, really needed to have something made quickly, had something made well.
It's a balanced meal.
I think if it all plays together, then I think that's the most important ingredient. It's not just one ingredient, it's kind of everything together.
And if you have all those ingredients meshing all simultaneously, that first bite you take is like having those pop rocks explode in your mouth.
They're so synonymous now with San Francisco that they're really closely intertwined, much the same way that, say, like fish tacos in San Diego are, or like steaks in Texas, or pizza in New York.
And welcome to the grand opening of our Don Fisher Clubhouse. My name is Maxine Wilson. Yeah, that's it. My name is Maxine Wilson, and I'm the Vice President of Operations for Boys and Girls Clubs of San Francisco. And today is a very special day for our organization, and we're very excited that you took time out of your busy day to come and celebrate with us. Today is also all about saying thank you and acknowledging all of the people who made today happen or make this building happen. First, I want to introduce you to some of our members who will come up and tell their stories in a little bit. So we have Kayla Craig, Ronika, are you Ronika? Ronika Singletary, LeVar Watkins Jr., and Ava Hayard. So throughout the program, our members will come up and share a little bit of their stories with you. Today, you'll also hear from our president, Rob Conley, who I just can't thank enough for his vision, for his leadership, and his passion. You know, he's worked with almost probably a lot of you in the room to make this amazing project happen, and again, I can't thank you enough. So I'd also like to welcome our city officials. So Mayor Ed Lee will be joining us around 3:30 for the ribbon cutting. We have the San Francisco Board of Supervisors President and District 5 President London Breed. We have Police Chief Greg Sir. We also have City Attorney Dennis Herrera. I believe I saw Supervisor Chris Weiner here. Scott, sorry. My bad. Sorry, Scott. And then a welcome to our special guest, Miss Doris Fisher, as well as Don and Doris's sons, Bob, John, and Bill Fisher. I'd also like to welcome Miss Barbara Callender, who's here with us. So our administrative office on the 3rd and 4th floor is named after Dr. John Callender, who was also a longtime board member. I'm sure we'll talk about that later. And then I also like to welcome our capital campaign co-chairs, so who made, again, tremendous amount of work to make this happen. Stephanie Millen, Rocky Freed, and Bob Emery. Okay, so then just a final welcome to our board members, our staff, parents, community members, and partners. Thank you guys again for coming out today. You'll hear, from a number of speakers throughout the day, and that's, we'll try to be tight so you can spend some time touring the club and the administrative office. After the program's over, we'll continue coffee and tea service in the dining hall, and then we'll also do clubs. So, a tour of the club. So, again, welcome. Thank you for being here. And now we're going to hear from our first youth speaker, Kayla.
Hello, my name is Kayla Craig. I am 10 years old and I'm in the 5th grade at Cradle Arts Charter School. I live in Robert B. Pitts Apartments, which is only about 8 blocks from the new Don Fisher Clubhouse. My neighborhood is fun, but it can sometimes get boring, and that's the main reason why I enjoy going to the old club in the Haight. I joined the Boys and Girls Club last June. I started going to Ernest Ingle because my best friend Kavani Robinson wanted me to. At the club, I really enjoyed hanging out with friends and going on field trips and even doing my homework. I am super excited to being one of the first members at the new Don Fisher Clubhouse. I remember taking a private hard hat tour with my new friend, Club President Rob, and some of my fellow members. The building was a little incomplete to say the least, but now that it's finished, all I can say is wow. It's looking totally different. I thought the old club was nice, but wow, I can't believe I get to call this my club. When we entered the club for the first time last week, I imagined all the fun things in store for us. I just hope I get to participate in everything. I am especially looking forward to swimming in the brand new pool and playing in this huge gym. I also want to check out the new dance program and the music studio. Basically, I'm just looking forward to the whole building. And of course, the staff. They make it all happen. Being a founding member of the Boys and Girls Club is an honor that I will carry with me forever. I am very grateful to everyone who made this possible. For all the kids, thank you for giving us a safe place to learn, grow, and have fun. And in the words of the club's namesake, Don Fisher, I'm ready to do what I love. Thank you.
Hi, my name is LeVar Walkins Jr. I'm 14 years old, and I'm in the 8th grade, and I go to AP Kennedy Middle School. I've been coming to the Boys and Girls Club since I was 7 years old. My mother enrolled me at the Ernest Engel Clubhouse because she wanted me to make new friends, get out of the house, and to keep me safe. I grew up in the Hayes District. She didn't want me to play or hang out outside because of the bad influence out there. But it got boring inside the house. I didn't understand then, but now I see what she was talking about and why it was so important to her that I was in a safe place like the Boys and Girls Club. I went to Grattan Elementary School, which wasn't too far away from the old club. There were staffs who picked us up from school and walked us to the club. I made a lot of friends at the time, and they are still my friends to this day. I was getting help with my homework when I first joined the Boys and Girls Club, and I still do. I participated in a lot of different programs since joining. When you're a little kid at the club, you participate in a lot of different programs like art, computer, music, swimming, gym games, in the game room. You get to see what you like and what you're good at. I even gotten to go to camp a couple of times. I played in the Pee Wee League when I was 7 years old. After I won the league's Rookie of the Year award, Nate, the citywide athletic director, asked me to join the Rebels basketball team. I didn't know what the Rebels program was, but I didn't even know what a tryout was. But at the time, Nate told me to try out, so I did it. I was the youngest player on the team, and there was a lot of competition, which made me nervous. I'm still on the Rebels basketball team, and thanks to Nate and the Rebels, I've learned to be confident, hard work, do my best, and to believe in myself. I don't allow myself to get unfocused and don't let people get in my head. I just focus on the game and do my best. Thanks to the Boys and Girls Club and the Rebels program, I've traveled to Arizona, Las Vegas, LA, and Oregon. I've been able to apply the things I learned on the court to my life. The club has really taught me how to be a gentleman. It changed the way I act and my attitude. I think that I'm more mature because of the experience that I've had at the club because of the staffs like Nate and Marquez. Nate pushed me athletically and helped me with more information about sports camps and programs. Marquez challenged me with my schoolwork. When I grow up, I want to be a professional football player. That's my plan A. But I don't know what my plan B is yet. I'm still trying to figure that out. The new club is wonderful. This is going to be the best club, Boys and Girls Club for sure. My favorite part is right here, the gym. This club is a lot bigger than the last one and a lot more kids near here. Instead of catching a bus, we can walk here from home. For kids who never come to the Boys and Girls Club before, you should sign up. You'll make new friends, participate in a lot of cool programs, and meet great staffs. If you need help with anything, they can help, and you'll have lots of fun. I'm looking forward to spend a lot of time here. Thank you.
Wow, there's more people here than I thought. So my name's Rob Connolly. I'm the president of Boys and Girls Clubs of San Francisco. And I just want to welcome you all here. Join Maxine in welcoming our distinguished guests and to say thank you for celebrating with us. Kayla, LeVar, awesome job. Really nicely done. It's not easy. So we're here today to celebrate all the good that's going to take place inside this clubhouse. My dream for this place is and will continue to be that it's a place of opportunity, inspiration, and hope. A place where kids feel loved, feel safe, feel empowered, and feel motivated to change the world. A place with the right programs and the right people. Somewhere in this building is our staff from the Don Fisher Clubhouse, and I think they kind of spread around. So if you're a staff member at the Don Fisher Clubhouse, do me a favor and raise your hand. Cool. So I'm pretty clear that as amazing as this building is and as inspiration as this building is, it is simply a means to an end. Really, the staff and the programs and the connection with young people is where this all comes together. And either works or doesn't work, and with this staff, I know it will work. My dream is also that this club will be filled every day with young people, and all day long in the summer. That kids will participate actively, that they'll show up 3 or more days a week. My vision is that there will be kids spread across ages, elementary school, middle school, and high school. My dream is that our parents will be our best advocates and our best partners, our best ambassadors, pushing us, especially on the developmental aspects of the programs that we offer here. That there'll be champions in the neighborhood and champions at City Hall. My dream is that when we look up in 5 years or 10 years, and we look around the Western Addition, Lower Haight, Hayes Valley, the rivalries between housing complexes become a thing of the past, and that it becomes clear that the Boys and Girls Club was one of the key reasons why. Not alone, mind you, but with other great programs in the neighborhood, like Cheryl Davis's program, Opportunity Impact, and her work with Mo Magic, the African American Art and Cultural Complex, local churches, really any other program focused on the positive and sustainable development of this neighborhood, its children, teens, and parents. I know that the clubhouse will be a place for skill building, for goal setting and goal accomplishment. But more than anything else, Boys and Girls Club is and will always be, always, always, always on the side of children and teens. So this project took guts. This is a ground-up building. Some of you were at the groundbreaking. It was simply a parking lot. It was expensive. It would have been far easier for us to stay in the Upper Haight and to sort of hope for the best. Much easier than closing that site, moving that building, and opening up here. But the right decision for us long-term, and now, was to be right here where the biggest need exists. So there are so many people I want to thank, and I need to move fast if I'm going to do it. So I want to thank my Board of Governors. I want to thank the Capital Campaign co-chairs. I want to thank the Fisher family, the GAP, who really stepped up when we approached them. I want to thank our partners in the New Market Tax Credit Program, U.S. Bank, Opportunity Fund, and the City and County of San Francisco. I want to thank the 5 past board chairs who are with us today, Bob Emery, Ellen Weissel, Steve Stramberg, Rocky Freed, Larry Nibby, and Bruce Callender, who's our current chair, is not here. He's in Hawaii. Good for him. I had 2 outstanding capital campaign chairs for the last 10 years, and they made it possible to raise the money that not only did this clubhouse, but we built a clubhouse on top of Hunters Point Hill, the Willie Mays Clubhouse. We rebuilt a club at 21st and Alabama and Eastern Mission, and we completely rebuilt Camp Mendocino. Bob Emery, Rocky Freed, you guys were unbelievable. I'm proud of the work that we did together, and I know that I was an integral part of the success, but I'm also real clear that you guys were way more important to this than I was. Your personal generosity and your networks were unbelievable, and you tapped into them, and I really appreciate it. 3 years ago, as we embarked on this project, we added a 3rd capital campaign chair, Stephanie Mellon. And Stephanie, you've been amazing. You gave this campaign the shot in the arm that we needed, because Bob and Rocky and I were getting tired. Your network and your generosity made all the difference, and I can't thank you enough. Finally, I want to spend just a minute or two talking about Don Fisher and John Callender. So as Maxine said, our offices for the citywide network of Boys and Girls Clubs of San Francisco are headquartered upstairs. I'm proud that these two men are remembered together at this building. They both joined the board in 1963 and stayed with us until the end of their lives, both approximately 50 years of involvement with us. Don, of course, founded The Gap along with his wife Doris. They drew national attention for their retail success and later their art collection and their philanthropic vision. At-risk youth have always been at the top of their list, and they have given generously to the Boys and Girls Club for over 50 years now. In 2005, when we embarked on the capital campaign that I mentioned earlier, we went to Don and his son John, and we made an ask, and Don and Doris became the critical leadership gift that launched the entire campaign that allowed us to do those 4 major projects. I also want to acknowledge 2 folks before I go to John Callender. Dennis Herrera, Chief Sir, in doing the club up in Hunters Point. I believe Alex Turk might be here as well. These 3 guys, that was a huge deal in going up on top of Hunters Point Hill and taking over Milton Myers. Thank you guys for what you did to make that project happen. So John Callender. John was more of a local legend than Don, in that Don was a bigger figure that transcended San Francisco. John was a man of incredible class, who seemed to be involved everywhere but somehow had time for everyone he came across. He somehow seemed to know what every staff member was up to, seemed to know right when to ask about a father, a son, a wife, or a child to see how they were doing. He had a world-class smile and a knack for fundraising. I'm proud that these 2 men's names are on our building. They embody the dedication to youth, passion for the community, leadership, generosity, and long-term commitment that define our organization's core values. Getting to today has not been easy, but seeing the young people in this club for the last week, swimming and in the gym and in the learning center, has been incredible. The energy that you feel, and then having you all here today, has been incredibly rewarding. Thank you all again for being with us today. You're going to hear more from me in a little while as I do some other personal acknowledgments of folks who made a meaningful contribution to this project. So at this time, it is my pleasure to bring up to the podium and introduce our District 5 Supervisor and recently now the President of the Board of Supervisors. A great friend to the Boys and Girls Club, has been at all sorts of events of ours in the last year, so thank you. We seem to be having a lot of events. And that is Miss London Breed. London, thank you for all your support and for all the leadership you provide to this community and now to the city.
Hello, everybody. Welcome to the Don Fisher Boys and Girls Club. I'm so glad that we have the girls. I think it started in the 70s when we finally start letting girls into the Boys and Girls Club. I remember growing up in this neighborhood and trying to get into the Boys Club at the time. And so what a great day to have our kids here today, to have this incredible club. I wish there was a club like this when I was growing up. Part of what makes a club special are the people who are going to be working with our young people. The difference in any child's life has everything to do with the folks like Nate Ford and Maxine and others who continue to work with our young people. And now, along with a great staff of the Boys and Girls Club, we have an incredible facility. This is so amazing. I'm a little overwhelmed because it just didn't seem like it was long ago when we were here breaking ground. I felt like that was yesterday. We broke ground, and what a difference money makes. This place is up, it's built, kids are here, and I just want to start by thanking Doris Fisher and her family for their commitment, their consistency, their genuine love, not just for San Francisco, but for kids and for making sure that young people in this amazing city have an incredible opportunity. And the Boys and Girls Club has truly been the place that most young people in our neighborhood had to go in order to have an opportunity. So thank you to the Fishers and your commitment to San Francisco, your commitment to the Boys and Girls Club. Thank you to the dedicated staff. And I really want to take this opportunity to thank, I see members of the Hayes Valley community who have been actively engaged in working to make sure that this club not only comes to the neighborhood, but it serves a lot of the young folks in this neighborhood. I want to thank Derek Brown, who I know has been not only working with my office, but also working with some of the developments, the housing developments in the neighborhood to make sure that kids who don't feel safe walking to the Boys and Girls Club, because we still have challenges in this community, that he's going to be picking them up and making sure that they have a way to get here so that they know that this club belongs to every single kid in this community. And one of the things that Rob didn't mention, and what they mentioned to me when we met to talk about this club, is now the ability to serve the kids in the Tenderloin. And so I am looking forward to bridging that gap and to bringing folks from all over the Western Addition community and folks from the Tenderloin. Our kids need a club and a place to feel safe and to feel secure, and they have that in the Don Fisher Clubhouse. And I just wish I was a kid again so I could have a good time here just like they are. Maybe every now and then I'll sneak over here and jump in the swimming pool or something. But I'm looking forward to it, and I want to, last but not least, really highlight and thank the Capitol, the committee who raised all of this money. As someone who used to run a nonprofit, I remember the work that went into even raising $1,000. It is a time-consuming process, and I know that you all raised millions. And that was the difference that made this club possible. That was the difference in making this club open sooner rather than later. And that's going to be the difference in making sure that our young people have a place to call home, a place to feel safe, a place to feel secure. And so I wanted to ask Bob Emery and Rocky Freed and Stephanie Mellon to come up and accept an award. A well-deserved standing ovation for those who have dedicated their lives to raising funds to make sure that this clubhouse was available to the next generation of young people. We couldn't have done it without you. And so on behalf of the City and County of San Francisco, since the mayor's not here, or is that the mayor walking in? Oh, hey, Mr. Mayor. I was just about to say I'm the top person in the city right now. But since the mayor's walked in, I can't say that. I can maybe say I'm the second now. So on behalf of the City and County of San Francisco, on behalf of the folks of this community, on behalf of everyone who is going to walk through those doors and enjoy this clubhouse for generations to come, we say thank you. We are truly thankful and honored that you have chosen to commit your lives to making this clubhouse possible. So thank you. I'm done, right? Okay. I know the kids are saying, hurry up with all this stuff so we can play, right? Soon enough. Don't worry.
So we got ourselves organized, and here is a recognition for you for your support of the building of this clubhouse. We really appreciate it. Thank you. Someone might take a picture of us, right?
Hi, I am Ranika Singletary. I am 18 years old, and I go to George Washington High School. The Boys and Girls Club of San Francisco has been a part of my life since I was in the 3rd grade. My father was a member as a kid and worked here as an adult. That's how I got introduced. I was really excited to join because it really looked like a fun place to be. One of my teachers once told me that a lot of free time leads to bad things. I live in the Western Addition, Plaza East, just a few blocks away from here. And many kids in my community who don't come to the club and just hang out, I tell them to come to the Boys and Girls Club and stay out of trouble. There's a lot of challenges where I come from. During my sophomore year of high school, I was standing outside talking to my auntie when someone drove up and started shooting. I looked down and seen that I've been hit. I couldn't feel down about it. I chose to be positive and move on. My mom died my freshman year, and me getting shot made me feel like I let her down, even though I know it wasn't my fault. I was on an honor roll, but my grades went down. With the help from the Boys and Girls Club, I raised my GPA from a 2.0 to a 3.0. They believed in me and made me believe in myself more. The Boys and Girls Club staff are role models and have motivated me to do well in school. They're always on top of me and encourage me to do better. I know that I'm making my mom proud. I love the club, and I am thankful for everyone who's here and the kids I got to build bonds with. For the kids who have never been to the clubhouse, this is a club where it's all about kids, and you'll build new bonds and have a place where kids can be a kid. I know the club is going to give you what it gave me and much more. All right, I'm done.
Good afternoon, everyone. My name is Spencer Tolliver, and I'm the Clubhouse Director for Don Fisher Clubhouse. Before I get started with my words, I'd actually like to really thank a couple of people, quite a few people. First off, my team. When Rob talked about having a top quality team, I truly believe that. I couldn't ask for a better group of people to work with. They have my back. Hopefully I have.
We're back in public session. The San Francisco Ethics Commission meeting for February 23rd, 2015. Having been in closed session, the commission voted not to disclose the contents of the closed session, other than to say that it voted and requested that Supervisor Farrell file a response no later than March 15th to the commission's forfeiture letter that has been previously served on him.
And you need to put that in the form of a motion, like we did in closed session.
Pardon me?
That needs to be voted on.
All right.
I so move.
We want to make that a motion?
I so move, Mr. Chair.
Second. All right. All those, any public comment? There being no public comment, and the commissioners have any comment before we start? Vote? All right. Call for a vote. All in favor?
Aye.
Opposed? Carried 4-0. Turning next to item 9, discussion and possible action on the minutes of the Commission's meeting of January 26, 2015. Commissioners have any comments? Any public comments? Hearing none, I'll entertain a motion.
Move that we approve the minutes as drafted.
Second.
All right. All those in favor?
Aye.
Aye. Opposed? Motion is carried unanimously. Number 10, discussion of Executive Director's report. Jack?
I just have one quick highlight regarding statements of economic interest. They are due for filing on April 1st this year. In addition to sunshine and ethics forms, we will be sending out a reminder this week to the commissioners and instructions. And obviously, if you need any help, you can let us know. Part of what is stated in the ED report is that we're not waiting for the state at this point to develop a statewide format. Instead, moving forward, we did indicate earlier we're going to be seeking public input on the searchable database of the Form 700s. I just let the commissioners know our first interested persons meeting is this Friday. So we're moving ahead on that.
Commissioner Keene?
Yes. Mr. St. Croix, can you tell us what progress you've made on the making our materials available in the multiple languages of San Francisco?
Thank you for bringing that up. I did mean to. So we had gone through, someone from the Language Access Office met with us, and we have gone through the pertinent documents and gotten advice from them on what they thought were the most important. We've identified those documents that we're going to translate. We've also identified the cost, and we're working with them to set up a timetable. They're going to hook us up with services that will do the translations. It is going to cost a little bit more than I'd hoped. I think we can cover most of the initial costs, but I'm anticipating we might ask for a small supplemental appropriation. The estimates they have right now, what I first have to do is get permission from the mayor's budget office and the controller's office to transfer some funds from other accounts, and then we'll see how much we have left. But we anticipate to begin starting those translations this year and possibly get those documents. I'm not going to say all done by the end of the year, but we'll certainly make progress this year in getting some done. The other thing we want to make sure we do, because a lot of our documents are updated on a yearly basis, particularly the manuals and guides, is make sure we get some sort of proprietary ownership of the original documents so that when we update them, we only have to update those sections that are changing rather than redoing them, the whole thing. But that is underway.
Thank you.
Yep.
Right, thank you. Item 11, items for future meetings. Anybody have any items they want to suggest to the staff for future meetings? There being no public here, the public has no suggestions, I understand. And item 12, I'll entertain a motion to adjourn.
So moved.
All in favor?
Aye.
Aye. Meeting is adjourned.